Good morning, everyone. We will just allow about 2 minutes so that we can have people join the session before starting. So we'll start in 2 minutes. Thank you.
Good morning, everyone.
Good morning, Diana.
Good morning, Diana.
Nice to see all of you finally.
Morning.
Good morning. So we started broadcasting. We will just allow a couple of minutes so that enough people can join. I think about 16 participants have joined already. So we'll allow maybe 1 more minute, then we'll start.
Sure.
Okay, I think this may be the perfect time to start. Um, Let me start by saying good morning to everyone. As the convener and the lead facilitator for this important training, it is indeed my pleasure to welcome you all to this training. This is a real opportunity for small and medium enterprises in Ghana to acquire the necessary knowledge for resolving their disputes outside the courtroom and also understand the principles of contracting. Now, this training is essential due to the current prohibitive cost of resolving disputes through litigation, which has become unattractive and unaffordable for SMEs. By necessity, it is pertinent for SMEs to resolve their disputes in a manner that is cost effective, efficient, and one that enhances business sustainability. So, the training is designed to help SMEs in Ghana to understand the rudiments of contracting, which is the first session we'll be having today. We'll also be learning the nuances of contract management, dispute avoidance and prevention, the various ADR methods, the pros and cons of these methods, and how SMEs can explore this knowledge for their business growth and sustainability. Now, I just thought to show how important SMEs are to the economy to further justify the objective of this training. Now, the SME sector is the backbone of major economies. As you can see from the screen, they are important contributors to employment, economic and export growth. In Nigeria, I've thought to show the figures in Nigeria and in Ghana. In Nigeria, SMEs contribute 48% of the national GDP and account for 96% of businesses and 84% of employment. In Ghana, SMEs contribute an estimated 70% of Ghana's GDP and accounts for 85% of employment in the Ghanaian manufacturing sector. And moving to South Africa, SMEs account for 91% of the businesses in South Africa and 60% of employment and contribute 52% of the total GDP. Now, despite the significant contributions of the SMEs to the Ghanaian sector or Ghanaian economy, challenges still persist that hinder the growth and development of this sector. The independent survey on SMEs in the UK that was conducted some years ago shows the financial impact of legal issues on SMEs. And as you can see from the screen, more than 13.6 billion pounds is spent every year, expended every year by SMEs on legal issues. This survey has provided some shocking revelations that should make every business sit up and take notice. It is almost impossible to imagine what impact the loss of 13.6 billion pounds might have on the SME economy. There's another analysis by Escalate Survey, which I've also put on the slide. The 2019 survey shows that 96% of SMEs regularly experience commercial disputes. So, as an SME owner in any industry or in any sector, engaging properly with your legal issues and guarding against them is going to potentially save you millions of cedis or billions of cedis every year. Simple matters like having contract terms and conditions checked or drafted properly to ensure your employment or contractual terms are clear will de-risk your business rapidly. It is also important to manage your disputes efficiently or establish safety nets to sidestep them. I have advised several SMEs in more than 10 years of practice, and some of the complaints are, oh, legal action is difficult to justify as it will certainly take longer to receive payment overall. Well, it's paid in the end, but not by my rules, but by their rules. It can be time consuming or cost prohibitive. It is very expensive to instruct lawyers. Some even conclude that the process is not worth it or only puts financial pressure on their businesses. While these complaints may be true for traditional litigation, ADR provides useful alternatives that will not only help you to obviate to sidestep these concerns, but also help your business to continue to move and operate as a going concern. So this training is designed to help SMEs understand, how to contract, how to manage your contract, how to manage your disputes, and how to resolve your dispute efficiently. Starting today, we're starting with Keneth Ohene-Manu. His profile is on the brochure that has been circulated to all of us. He's a professor in one of the institutions in Ghana. And at this juncture, I will invite Keneth to take us through his session. Thank you, Keneth.
Okay. Thank you very much, Abayomi. As for the professor status, I haven't reached there yet. So thank you very much for the introduction. So just give me a moment for me to share my screen, then we can proceed. Okay. So today we're going to be discussing contracts, drafting, understanding, drafting, and negotiating contracts, and navigating some regulatory issues. So this session has been, has been broken down for everyone to understand. It has been made very simple to train people who work for SMEs to have knowledge that they can negotiate and draft their own contracts. Okay, so it has been broken down. The contract law has a lot of rules and regulations and cases. No, we've moved that. It's been made very simple for everyone to understand. Okay. So let me go to the introduction. So as I said before, employees of SMEs, as you often have, are tasked with drafting and negotiating contracts for different matters, various matters. These include contracts for the employment of staff, services such as cleaning, security, catering. There's a lot to contract for everything. Okay, contracts for the purchase of items, electronics, equipment, all that. But due to the nature and size of SMEs in Ghana, generally, some are bigger than others, but generally due to the nature, the size of the company or the entity or the enterprise, it's getting a lawyer to look through your contracts for you or to advise you on your contracts before you enter into a contract becomes very difficult because it can get quite expensive, and it's not every contract that you have to send to a lawyer. Fairly simple contracts, and with relevant, with proper training, you should be able to negotiate and draft it yourself. So this session aims to improve the skills of especially those responsible for drafting, negotiation, and implementation of contracts, SMEs, so that for this session, once a contract comes to you or you are negotiating a contract or you want to enter into a contract with another company or a person or another entity, you have some basic skills and basic knowledge and basic pointers or tips to use when you are drafting and negotiating such contracts. So I'll take you through the course outline. Let's give it a moment. Okay. So first of all, we'll discuss the overview of contract formation, just an overview of how contracts are formed. We'll go to contract pricing and the scope. Review some of the standard language in the contract, such as insurance requirements, indemnification, liquidated damages, third-party rights, suspension, termination. And we'll also discuss some very key clauses in contracts, very key clauses in contracts that you have to pay attention to, such as the governing law clause, the dispute resolution clause, jurisdiction and choice of law clauses, which go hand in hand. And then the next part, we'll discuss how to avoid and prevent disputes. Okay. Dispute avoidance and prevention in relation to contracts. So you don't have to wait for there to be a problem. You can take certain measures that will prevent you or avoid there being a dispute. The next one we'll discuss navigating some regulatory issues related to contracts in Ghana. So this is the course outline for the session. And before I continue, if you have any question, you can type it in the Q&A column. And then as we go on, as I go on, I will answer the question. So if you have any question, you can type it in the Q&A column. answer the question. All right. So first of all, we'll start with overview of contract formation. But first of all, what is a contract? What is a contract? I'm sure most of you have heard or have dealt with contracts. What is a contract? A contract, and this is a very simple definition of a contract. It's a simple basic definition. So a contract is a legally binding document between at least two parties that defines and governs the rights and duties of the parties to an agreement. It's basically a legally binding document between at least two parties that defines and governs the rights and duties of the parties to an agreement. And you know that contracts can be both written and oral, but for the purposes of SMEs and the kind of contracts that SMEs enter into, it is prudent that contracts that SMEs enter into should be in writing. Then they should be in writing because of the nature of the SMEs. If it's a contract between you and a friend, like an oral, but for SMEs, the kind of contracts that SMEs enter into, it's prudent that the contract should be in writing. So this is the basic definition of what a contract is. How is a contract formed? How is a contract formed? A contract is generally formed when there's mutual assent. That is, when two parties agree to enter into a contract. The two parties, their minds must meet. There must be a meeting of the minds between the parties to enter into an agreement. And this should be supported by something known as consideration. Consideration can either be money or something given in exchange for a promise. Okay. So a contract is formed when there's an understanding between the parties, when the parties meet and agree that they should enter into a contract. That's how a contract is formed. And throughout this session, I'll be using two companies or two makeshift companies. These are not real companies. These are just used for the purpose of explaining some of the principles. So I'm using Enidaso Limited and Takwa Limited. You see these two names throughout the session. Various scenarios that will help explain some of the principles I'm talking about. For example, if Enidaso Limited and Takwa Limited, let's say there are two main companies, Enidaso Limited and Takwa Limited, right? These companies mutually agree to enter into an agreement for the purchase and sale of office furniture. And I'm sure a lot of SMEs or a lot of your companies enter into various agreements, including the purchase of office items, furniture, equipment, television, electronics, and all that, different things. So let's say Enidaso Limited and Takwa Limited mutually agree to enter into a contract for the purchase and sale of office furniture. And that agreement is supported by money or something given in exchange. Then we can say that a contract is formed between Enidaso Limited and Takwa Limited. Okay. And I can see a question. Someone is asking, please, will we get the slides? I'm sure the slides will be uploaded. Have it after the sessions. So we cannot talk about contracts without looking at the key elements of a valid contract. For a contract to be valid, there has to be some key elements in it. So it's very necessary to talk about this in passing, not in detail. So the elements for a valid contract are offer, acceptance, intention to create legal relations, and consideration. So let's look at the first key element, which is offer. What is an offer? So an offer is a statement by one party of a willingness to enter into a contract on the terms provided by that person. Okay. So let's use the example. For example, if Enidaso Limited, our favorite Enidaso Limited, expresses willingness to enter into a contract with Takwa Limited, okay, on terms which Takwa Limited can accept, then Enidaso Limited is deemed to have made an offer. Okay. Enidaso Limited will be deemed in such a circumstance to have made an offer. So that Enidaso Limited will become the offeror, and then Takwa Limited will become the offeree. So the one making the offer is known as the offeror, and the one who the offer is made to is known as the offeree. So an offer is one of the key elements of a valid contract. First of all, there has to be an offer. One of the parties must make an offer containing certain terms and conditions to the other party. The one making the offer is the offeror. The one to whom the offer is made is known as the offeree. The second key element of a contract, second key element of a valid contract is acceptance. So the acceptance is an acceptance. An acceptance is an agreement to the terms of an offer. So if Oluwaseyilay Limited makes an offer to Takwa Limited, Oluwaseyilay Limited is the offeror, and Takwa Limited can choose to accept the offer. Okay. So, for example, if Takwa Limited accepts the offer of Oluwaseyilay Limited, then generally there's a binding agreement or contract between the two parties. I use the word generally because subject to several exceptions, but generally there's a binding agreement or contract between the two parties. Okay. The first key element is offer. One of the parties will take an offer. The other party must accept the offer. Okay. And the next key element is intention to create legal relations. When an offer is made to someone, the other person accepts. The two parties agree. They agree in principle, right? But then there must be an intention that what they have agreed to should be a contract. So the parties must have an intention to create legal relations. If Oluwaseyilay Limited makes an offer to Takwa Limited, Takwa Limited accepts the offer, then there's a kind of an agreement between the two parties. The question is, the agreement, do they intend for it to create legal relations? Do they intend for it to be a binding contract? Okay, so that's the next element, intention to create legal relations. So there's a presumption in law that for social or familial agreements, that is agreements between you and your family, like you as a person and your friend and your family, those contracts, for those agreements, there's a presumption that the parties do not intend to create legal relations. However, when it comes to agreements of a commercial nature, such as agreements that SMEs will enter into, there's a presumption in law, there's a presumption that the parties to the agreement intend to be bound by it. Okay. So let's use the same parties. If Oluwaseyilay Limited makes an offer to Takwa Limited to sell certain items, let's say for the purchase of equipment, office equipment, okay, offer is an acceptance. Because the agreement between the parties is of a commercial nature, okay, there's a presumption in law that the parties intend that there should be a binding contract between them. Right. Okay. So let's look at the last element, key element of a valid contract. That is consideration. Consideration is anything of value promised by one party to the other when making a contract. So consideration is not necessarily money, but usually in commercial agreements, the consideration usually will usually be money. Okay. So consideration is very essential, it's very key to the validity of any contract. In fact, if there's no consideration in the contract will not be enforceable. Okay. Without consideration, an agreement is generally not binding and not enforceable. So consideration is anything of value promised by one party to the other when making a contract. Okay. And the scenario, the example is that if Oluwaseyilay Limited enters into a contract with Takwa Limited for the purchase of furniture, okay, for let's say 5,000 Ghana cedis. Okay. Oluwaseyilay Limited's consideration would be the sum of say 5,000, the sum of 5,000. So let's say Takwa Limited is supplying the furniture to Oluwaseyilay Limited. So Oluwaseyilay Limited's consideration is that Oluwaseyilay Limited has to pay 5,000 cedis to Takwa Limited, and Takwa Limited's consideration will be delivering the furniture. Okay, so it's an exchange. Anything of value promised by one party to the other when making the contract. So Oluwaseyilay Limited will say that if you give me furniture, I'll pay you 5,000. And for Takwa Limited, if I deliver the furniture, I'll see 5,000. So that is in sum what consideration is. So in sum, these are the elements. This is a summary of the elements of a valid contract. So let's move on to the next subtopic, that is contract pricing and scope. So we are done with the elements of a valid contract. Now we come to the contract itself. Contract pricing and scope. When anytime a company is entering into a contract, or an SME is entering into a contract, or your company is entering into a contract, one of the key elements is the price, okay? Because you're going to pay for the item. If it's a service, you're going to pay for the service. If it's goods, you're going to pay for the goods. So the contract price is very key in any contract, okay? The contract price, one thing you must note is that the contract price must be stated expressly in the contract. Must be stated expressly in the contract. And the parties in the contract, if you are drafting or negotiating the contract, you are free to determine the manner in which the contract price will be paid. Okay. There's no hard or fast rule as to how the contract price will be paid by one of the parties. Okay. The parties to the contract can decide how the contract price will be paid. So depending on the agreement between the parties, the contract price can either be paid in full upon delivery of the goods or the provision of the service, or can be paid in installments. So for example, the parties may agree that Enidaso Limited should pay the contract price in full as soon as the furniture is delivered, or the parties may decide that Enidaso Limited should pay, let's say, 50% of the contract price, that is 2,500, upon the execution, the signing of the agreement, and then the remainder should be paid upon delivery of the furniture by Taka Limited. And the parties can also decide that the contract price should be paid in advance of performance. So we can say the parties can agree that Enidaso Limited should pay the contract price prior to the supply of the furniture, or as soon as the contract is signed, is executed. So the parties are free to determine how the contract price paid, the manner in which the contract price will be paid. But it must be stated expressly in the agreement, the contract, to avoid any disputes. It must be stated clearly. So when you're negotiating the contract, or you're drafting the contract, you must ensure that the contract price is stated expressly in the contract. The next clause is, the next one is insurance requirements. Insurance requirements. Okay. So for certain kinds of agreements, okay, insurance may be required. Insurance provisions they're not contained in every contract. For some contracts, it might not be necessary to have an insurance provision inside the contract. Okay. However, for certain types of contracts where, let's say the goods are if it's for the purchase of goods, or supply of goods, and the goods are very valuable to the extent that if something happens to the goods, it gets damaged in transit, something happens to the goods, it will be very, there'll be a heavy burden on the party supplying the goods if the goods are destroyed and that party has to pay for it. The other party too might sue for breach of contract because the goods have not been delivered. So it becomes very difficult. So for some kinds of contract, depending on the kind of contract, if it's something, it's for the purchase of something which is very valuable, very, very valuable, or for a service which is also very valuable, it would be prudent to have an insurance clause in the contract. Okay. So to manage any unintended results, insurance options should be considered in the contract, okay, so that the parties will be cushioned for any legal fallout. Okay. So insurance clauses, they are very necessary in a contract if the parties' performance or non-performance will result in damages beyond the defaulting party's obligation to pay. Okay. And this will be especially can especially happen in the event of bankruptcy or insolvency. Which party should arrange for the insurance? Which party should arrange for the insurance? So this depends on the nature of the contract, and it also depends on the risks associated with a particular contract. Let's go back to our Industrial Limited and Kappa Limited. So let's say that in the contract between Enidaso and Kappa, the contract provides that Enidaso should pay the total contract sum upon the signing of the agreement. And then during the transportation, the vehicle transporting the furniture is involved in an accident and the furniture gets destroyed. Let's say the car, there's a cause of the impact, the car bends, there's fire, and the car, all the furniture is destroyed. The person who will be responsible for the loss of the furniture when Enidaso Limited has already paid the price. So let's say they've paid upfront. During delivery or during transit, the furniture gets destroyed. What will happen? To prevent such a situation, it's very necessary for the parties to the contract to have an insurance clause in the agreement, which will provide that the supplier or Takwa Limited must arrange insurance with a reputable insurance company so that in the event of a loss, the insurance company will pay for that loss. So depending on the nature of the contract, the kind of contract that you're entering into, you have to be, it's not every contract that's to be necessary for you to have an insurance clause. It's not every contract, but if you look at the nature of the contract and you think that if something happens in transit, for example, if it's goods, something happens in transit and become very burdened when the goods are destroyed, and it's advisable to ensure that there's an insurance clause, and you must ensure that you actually take the insurance. So it's not just putting the insurance clause in the contract. The insurance has to be taken, has to be arranged. Okay, so it's not just enough to just put it in the contract and leave it. And when there's a problem, we'll find out that the party who was responsible for taking the insurance did not do it. Okay, it must be actually taken. So in some situations, it's very necessary for there to be an insurance clause in the contract. Okay. So how do you get an insurance clause right? How do you get an insurance clause right? Some of the insurance clauses, depending on the contract, can be a bit confusing. Let me put it that way. It can be a bit confusing. Some of them are a bit complex. How do you get an insurance clause right? So in order to have a very good insurance clause, it's very helpful to let a professional insurance agent or a broker look at it, because they understand the mechanics of insurance. Once it's drafted, you can let an insurance broker or an insurance expert or an insurance professional look at it, just take a look at it, so that you would correct any mistakes or any ambiguities in the insurance clause. Okay. So we are still on the review of standard language in the contract. The next one is indemnification. These are pretty common clauses in contracts. You have a section or a part of the contract which will say indemnification. So what does it mean to indemnify? What is indemnification? What does it mean to indemnify? It's simple. To indemnify means to compensate for harm or loss. Okay, it means to compensate for harm or loss. So indemnification clauses in contracts will generally provide for protection against lawsuits, government actions, and actions for third parties. So these clauses generally obligate a party, one of the parties. So there are two parties. Let's say Enidaso and Takwa Limited. Obligate one party or either party to compensate the other party for losses or damages that have occurred or could occur in future in relation to the contract. So it is in relation to the contract, not any other thing there. You will compensate the other party for a loss that the party incurred in relation to the contract. Okay, it has to be connected to the contract, okay, in relation to the contract. So let's take a look at a typical indemnification clause. There are different ways of drafting, but this is a sample, this is a template. So this is how a typical indemnification clause looks like. So I'm just going to read it. So each party, and again, I'm using the Industry Limited and the TAQA Limited. Each party shall defend, indemnify, and hold harmless the other party and its affiliates, directors, officers, and employees from against any and all suits, actions, penalties, damages, losses, liabilities, costs, and judgments rising out of or in connection with any claim relating to the products and services of the indemnifying parties. You can see it's a very quite services of the indemnifying party. So the indemnifying party is either Industry Limited or TAQA Limited. So this clause, it has been added together. You can, if you want it to be clearer, it can be separated. Okay, but this one is put together. That's how come the language is binding. Okay, so continuing. Either Industry Limited or TAQA Limited, or as a result of or in connection with any breach by the indemnifying party of any of its representations or warranties set forth in the agreement. So let's break down this clause. So if Industry Limited, so the import of the clause is that if in Industry Limited suffers any actions, penalties, damages, losses, liabilities, costs, judgment, and all that, as a result of Industry entering into a contract with TAQA Limited, so it must be connected to the contract. That's what it must be. They must be connected to the contract. It shouldn't be something outside the scope of the contract. If the Industry Limited suffers these things as a result of contracting with TAQA Limited, then TAQA Limited is obligated to indemnify Industry Limited. That's generally the agreement to provide for circumstances under which party will indemnify. There will be more detail, but this is just to give you a general understanding. So generally, if Industry Limited suffers any actions and all that as a result of it entering into a contract with TAQA Limited, subject to other provisions, then TAQA Limited will be obligated to indemnify. So in a similar vein, so it's both ways. So in a similar vein, if TAQA Limited also suffers actions, penalties, damages, losses, liabilities, costs, and judgments as a result of TAQA Limited entering into a contract with Industry, and that is also subject to various provisions in the agreement, then TAQA Limited will be obligated to indemnify Industry Limited for the loss or damage. So that's basically what indemnification is about, and it's very important. It's a very important clause in a contract. So when you're negotiating, drafting a contract, you must ensure that there's an indemnification clause. It's a very important clause. Okay, so the next one is liquidated damages. Liquidated damages. So what are damages in the first place before we come to liquidated damages? What are damages in the first place? Damages are a sum of money awarded by a court as compensation for a breach of contract. I'm sure you've heard the term breach of contract so many times. It's a very common phrase that is used. I've heard it around the world. Breach of contract, breach of contract. So it's one of the remedies that a party is entitled to when there's a breach of contract. Those are damages. Okay. When you hear damages in relation to contract, it's basically a sum of money awarded by a court as compensation for a breach of contract. So that's what damages is. Let's come to liquidated damages. So liquidated damages are it's a predetermined sum of money that must be paid as damages for failure to perform as required under the agreement. So for liquidated damages, it's actually put in the agreement that if party A fails to perform this amount of money, then that party will be liable to pay party B this amount of money. So it's predetermined, okay, predetermined and agreed to by the parties. So that when as soon as that party defaults or breaches a particular provision of the contract, then that party will be liable to pay that liquidated damages to the other party. So it's a predetermined sum of money that must be paid as damages for failure to perform as required under the agreement. So let's look at our Industry Limited and TAQA Limited. So there may be a provision in their agreement, okay, the agreement between Industry Limited and TAQA Limited, to the effect that if TAQA Limited fails to deliver the furniture to Industry Limited as provided in the contract, then TAQA Limited will be liable to pay a specified sum to Industry Limited as compensation. So the damages is the parties agreed on a predetermined sum of money So they could say that, okay, if you fail to deliver on time, let's say you're supposed to deliver on 20th May by 12 p.m. Let's say that you deliver on 25th May. So the parties may agree, okay, in such a situation, if you fail to deliver on time, then you'll be liable to pay this amount of money. And any amount of money that the parties agree on. Okay, so this is predetermined by the parties. All right. So what are the benefits of a liquidated damages clause? What are the benefits? What is the importance of it? So liquidated damages clauses, a liquidated damages clause can establish some form of predictability. It can act as a type of insurance against the contract breach. So if a party has to perform certain obligations, that is, let's say Takwa Limited has to deliver the furniture by a certain time, they know that if they fail to do it, they're liable to pay a particular sum of money to Ohene-Manu Limited. Okay. So they can, the parties can weigh the cost of performance against cost of breach. Because you know that if you breach that particular provision in the contract, you're liable to pay this amount of money. So it brings some predictability and can act as a type of insurance against the cost of the breach. Okay. And deciding on damages at the beginning, okay, at the point of negotiation, gives the parties the opportunity to settle an amount that they think is fair. So the parties who agreed, okay, if I do this amount, so during negotiation, that's that if you fail to deliver on time, you pay like 10,000 cedis. The other party said, no, that is too much. So the parties will negotiate, okay, fair amount that will be paid for the breach of a particular provision in the agreement. So it's very, it is necessary, or it will help. It's advisable, let me put it that way. It's advisable to have a liquidated damages clause in your contract. So when you are negotiating, drafting a contract, it's necessary that you have a liquidated damages clause in the contract. All right. The next one is review of standard language. We're still on review of standard language. Third party rights. Third party rights. Before we discuss the third party rights, let's look at, there's a principle of contract known as privity of contract. Okay. It's one of the basic principles of contract law. It simply states that it's only parties to a contract that can sue or be sued in relation to the contract. In a contract between Ohene-Manu Limited and Takwa Limited, they are the parties to the contract. Okay. XYZ Limited or a third person is not a party to that contract. So generally, that person should not be able to sue to enforce that contract. That's what basically the privity of contract doctrine is and says. Okay. Even though in Ghana, in our contract acts, there's an exception or some exceptions to this rule that only parties to a contract can sue or be sued in relation to the contract. That is an exception. So it's better to know that in the Contracts Act, there's an exception to it. But generally, it's the parties to a contract who can enforce a contract. Generally, that's a general rule. So should there be clauses in the contract conferring third-party rights? Okay, should there be clauses in the contract that would allow persons who are not party to the contract to sue, to enforce a contract? Okay, should it be allowed? Is it advisable to do that? So, permitting third parties to have rights under a contract, it can expand the exposure of the parties. Okay. Because here is Ohene-Manu Limited contracting with Takwa Limited for the purchase of furniture. Takwa Limited will supply the furniture. If, let's say, XYZ Limited is allowed to sue under the contract, or sue to enforce a contract that is not a party to, it could expose the parties to it. So generally, it is not advisable to permit third parties to have rights unless the parties sit down and agree and confer third party rights on somebody to sue to enforce a contract for any other thing. But generally, it exposes the parties. Okay, because the person who is suing to enforce the contract or sue or any other thing is not a party to the contract. So it can expand the exposure or risk of the contracting parties if you allow third parties to, especially a third party who does not really benefit from the contract. Okay. If it's a third party that benefits from the contract, and going back, the Contracts Act, the Contract Act in Section 5 provides that if a contract confers a benefit to you being a third party and you are not part of the contract, you can sue to enforce a contract in relation to you. But if the third party is not going to benefit from the contract, then it is not advisable to expand the scope of the contract to allow third parties, especially third parties who will not benefit under the contract, to be allowed to sue to enforce a contract or any other thing. So that is third party, basically an overview of third party rights in a contract. Then we come to suspension. Suspension of a contract. What is a suspension of a contract? What does it mean that for a contract to be suspended? Okay. So contract suspension is the temporary cessation of performance. Okay. So performance of the contract is halted. That's what is meant by suspension. If the performance of the contract is halted or is halted temporarily, temporary cessation of performance, and that is suspension. So in the contract suspension, either the parties can suspend the contract for specific reasons outlined in the agreement's terms and conditions. So the contract can provide that on the occurrence of a specific event, the parties or one party or other parties or one party can suspend performance of the contract. Okay. As I said before, the reasons may include a change of circumstances which would make the performance of the contract possible or impractical. So let's take a look at our two companies, Takwa Limited and Ohene-Manu Limited. So let's say, for example, after Ohene-Manu and Takwa have signed a contract with the supplier of office furniture, there's a large fire at the warehouse of Takwa Limited, okay, which makes it impossible for them to deliver the furniture. So let's say that at this point in time, Ohene-Manu hasn't paid anything for the furniture. And Takwa Limited, that is responsible for delivering the furniture, has an accident or something happens at the warehouse and everything is bent down, which holds operations for some time. Such a circumstance, there could be a clause in the contract that if events of such a nature happen, then the contract will be suspended to enable one of the parties put its house in order. Otherwise, if it's not suspended, it means that they've breached the contract. Okay, so it's very necessary to have suspension clauses in our agreement. When you're drafting or negotiating an agreement, it's good to have suspension clauses in agreement to cater for certain situations where certain situations that will make performance of the contracts impossible at a particular period or impractical. And this must be specifically mentioned in the contract. Okay, it must be specifically mentioned. If you want the parties to have the right to suspend the contract, then when you're negotiating on the contract, it must be stated expressly that the parties have the right to suspend the occurrence of a specific event. Okay. If it's not stated, it will be very difficult for a party to try and assert this right. So it must be expressly mentioned in the contract that the parties upon the occurrence of an event or something can suspend contracts. So a suspension clause is necessary. Yes, they are necessary, as what I've said, they are necessary. Okay. So to avoid any complications, it's advisable for parties to a contract to have suspension clauses. However, the suspension clauses must be detailed enough. Okay, they must be detailed. It mustn't be open-ended. It must be detailed to provide for matters such as the duration of the suspension, or happen when work commences, and all that. They must be detailed enough. But it's necessary. it's better to have a suspension clause in the agreement so that when something happens, it becomes impossible to perform the contract for a particular point in time. The parties are given room. Okay, so it's necessary, very necessary to have a suspension clause. It's not putting a suspension clause in the contract doesn't mean that you want something to happen, but it's advisable to have it anyway, so that when something happens, there's something to cover that. So it's very necessary to have a suspension clause in the contract. Okay. So the next one is termination. Termination of a contract. Next one is termination of a contract. So what is meant by termination of a contract generally? In general terms, what is meant by termination of a contract? Terminating the contract means legally ending the contract before the parties have fulfilled their obligations under the terms of the contract. Every contract must have a termination clause. So when you're drafting and negotiating the contract, you must ensure that there's a termination clause. Every contract must have a termination clause. Termination clauses. Okay. So what happens when a contract is terminated? When a contract is terminated, the parties are discharged from performing the obligations under the contract. So the parties are no longer bound to perform the obligations under the contract. Okay. So let's use our two companies. So for example, the contract between Oluwaseyilay Limited and Keneth Limited, if it is terminated, then it means that Oluwaseyilay Limited will no longer be required to fulfill its obligations under the contract by paying for the furniture. That is if Keneth Limited is supplying the furniture. And Keneth Limited will no longer be required to deliver the furniture to Oluwaseyilay Limited. So when a contract is terminated, the parties are discharged from performing their obligations under the contract. When it's terminated, the parties are discharged. They are no longer required to perform the obligations under the contract. Generally, they are no longer required to perform the obligations under the contract. So that is termination. So what is a termination clause? What is a termination clause? What is meant by a termination clause in the contract? So termination clause is a written provision in an agreement that defines the circumstances under which the agreement can be terminated. So the termination clause in an agreement would outline the circumstances under which the circumstances by which the party or both parties or one of the parties can terminate the contract. That is to bring the contract to an end before it should come to an end. Okay. The circumstances under which the agreement can be terminated. So termination, the contract can occur before the duties of the parties set out in the agreement. And it can always be tailored by the parties. Okay. The parties can always fine-tune it to how they want it to be. That way, it can be tailored by the parties. What are the common what are the common grounds for termination of a contract? So some common grounds for termination are as follows. Mutual agreement. So it can be provided in the contract that both parties can decide at any time to mutually terminate the agreement. Okay, so when you are drafting or negotiating the contract, it's good to insert into it that the parties, depending on the nature of the contract, the parties can at any time mutually agree that they should terminate the contract. Okay. So for example, Oluwaseyilay Limited and Keneth Limited would mutually agree to terminate the contract between them. So the parties by mutual agreement can terminate the contract. Okay. Second common ground. This is not an exhaustive list, but these are some of the common grounds by which contracts can be terminated. Okay. So the second ground is impossibility of performance. If the contract becomes impossible to perform due to certain factors which would be listed in the agreement, then provided in the agreement that the parties or one of the parties has the right to terminate the agreement. Okay. So using our scenario, there could be a clause in the contract between the Daso Limited and Aqua Limited to the effect that if the contract becomes impossible to perform due to various factors which will be listed in the agreement, the contract should be terminated. Another common ground is breach of contract. Okay. If either of the parties, that is Daso Limited or Aqua Limited, the parties do not perform their contractual duties, then it consistent breach. So as part of the termination clause, there could be some clause that says that if any of the parties breach the obligations under the agreement, then one of the parties has the right to terminate. That is, the non-breaching party can terminate the agreement. So these are generally the common grounds for termination. All these will be subject to other limitations in the agreement, but generally, these are the common grounds for termination of the contract. So there are some important things to note for termination clauses in the contract. When you are drafting contracts, especially termination clause, there are some things that you must note. The first is that you should not accept a contract that requires you that you can only terminate when there's a breach. If you do that, you've tied yourself up. Okay. So generally, do not accept a contract that requires that you can only terminate when there's a breach. Okay. Ideally, the party should be able to decide that, okay, if we do not want this contract anymore mutually, we can both agree that we will terminate it. So do not accept a contract that requires that you can only terminate when there's a breach. Another point to notice, you have to be careful. You have to be careful of contracts that automatically roll over if not terminated within a certain number of days prior to or before the expiration of the contract. Okay, so you see that there's some contracts who say that, okay, this contract is for a period of or the
Sorry, I think we've lost Keneth. Um, so while I think we'll give him some minutes to reconnect back, and while he's reconnecting, uh, I see that is a question here that says, "What is the difference between a contract and a promise, and can a promise be a contract?" I don't know whether I should leave that for Kenneth or I should go ahead to answer it. So, well, yes, can a contract be a promise? Can a promise be a contract? Interesting question. Yes, a contract can be a promise, but for that promise to be enforceable in law, it has to be backed up by consideration. And I think Kenneth, in the course of the discussion that took us through the fundamental elements of a contract, starting from what you call your offer, uh, you know, to acceptance, then offer and acceptance makes what we call an agreement, and the agreement forms the bedrock of a contract. And I will try to expatiate on this. So you have your contract, say SMEA, is into uh, dairy products and needs some supplies from SMEB, and SMEB asks product to supply. So SMEA makes an offer to buy, while SMEB also accepts that offer to supply, and SMEA pays the price or the fee for that supply. So that's how it works in practice. So you have your offer and you have your acceptance, and that forms consideration. But the question is that the end of contracting? No. After offer and acceptance, there is what we call consideration. There is what we call intention to create legal relations. All these, and we also have capacity to contract because someone that is not in the eyes of the law legally capable of forming a contract or entering into a contract cannot contract under the law. So back to the question: is a promise a contract? A promise can be a contract if that promise is backed up by consideration. So another example is assuming a wife and the husband in a house in a domestic setting, and the husband decides to buy the wife an Escalade for her next birthday, and the next birthday comes, the husband refuses or is not able to buy that Escalade. There has been a promise to buy her an Escalade during her next birthday. The question is, can the wife take the husband to court based on that promise to say, well, you promised me an Escalade, but you don't bought that Escalade for me as a birthday gift. So there was a promise, but that promise, the question is, has the wife furnished any consideration? And the question is, was there intention to create legal relations on the part of the husband? Is that contract an agreement such that, or a promise that can be enforced in law? So it's not all promises that are contracts, but contracts include promise in the nature of an offer and what we call an acceptance, which forms an agreement. Kenneth may have further insight on this. Kenneth, are you back?
Yes, I'm back. Sorry about that. I think there was a hitch in the connection. So sorry about that. I'm back. Thank you. Yes, so I'm going to continue. Yes. Okay, so I was on the important things you must note for termination clauses. Okay, the first, what I said before the connection suddenly truncated was that do not set a contract that requires that you can only terminate if there's a breach. The next one is you have to be careful of contracts that automatically roll over if they're not terminated. If not terminated within a certain number of days prior to the expiration. Okay, so you have a contract which will say that okay, this agreement is for a period of 1 year, and it will automatically roll over. The agreement, there are a lot of contracts like that. They say that this agreement is for a term of 1 year, and it's automatically renewable unless terminated by the parties. Okay. So the implication of such clauses is that if you miss the opportunity to give notice termination in a particular period of time, and if you don't take care, you'll be bound to automatically renew, and you'll be committed for another period of time, depending on the period of time it is renewed for. If it's 1 year, 2 years, as you bound by it. You have to take note of such clauses. The next one is you have to demand a clause in the contract that allows for at least 30 days notice of termination. So let's say there are 2 parties to a contract, and the agreement allows the parties to terminate the contract. Okay. Sufficient notice must be given. Okay, you must be given sufficient notice. So it shouldn't be short notice. That can really disrupt the activities of the company. So when you're negotiating and there's very short notice, you have to demand that, okay, if I agree to the contract, if I agree that the parties can mutually terminate the contract, then at least there should be at least some sufficient period of time. So 30 days will be okay. But depending on the nature of the contract, it can be more than that. If the contract is a very complex one, it can be more than 30 days. It can be even 60 days. There's some parties, for some long-term contracts, it can even be months. Okay, so that the other party is given sufficient notice to prepare for the termination, especially when it's termination without cause, meaning that there's no breach of contract or there's no nothing has happened, there's no event that has occurred that has made the contract impossible to perform. If the parties mutually agree to terminate the contract, at least there must be sufficient notice to the other party. Okay. If one party is allowed to terminate the contract, there must be sufficient notice to the other party.
Right. I think Kenneth is still having issues with his connection. Of course, that is one of the concerns or challenges that we have with virtual training. So, well,
can you hear me now?
Time
can you hear me now?
Connect and do that. I think it should be useful to move, move on to the next. Keneth, are you back?
Yes, I'm back. Is it better now?
Yes, it is.
Is it clear?
Yes, please go ahead.
Okay, thank you. Okay, so I don't know whether you heard what I said the last night said, but I was saying that one of the important things to note when you are negotiating or drafting the termination clause is that you must demand that there should be sufficient notice in case one of the parties is allowed to terminate without cause. That is, without, if there's no breach in one party, if the contract allows one party to elect to terminate the agreement, then naturally the other party must have sufficient notice of that. If there's short notice, it can disrupt the activities of the company. Okay, so you must demand that there should be sufficient notice if you're negotiating. I was saying that depending on the nature of the contract, it can be more than 30 days. In some long-term contracts, the notice period can be at least 6 months. So that if I am entering into a contract with IOME and I want to terminate it, I must give him sufficient notice. If the contract allows me to do that, I must give him sufficient notice. So when you're negotiating, another party is saying that there should be short notice, you must demand a longer period. That will be satisfactory to the company. Okay. I hope you can hear me. I hope you can hear me before I continue.
Perfectly.
Yes, okay, that's good. All right. Okay, so we are done with the termination. The next one is governing law. So we'll discuss governing law, jurisdiction, and choice of law together. Okay. So governing law clause. This is a very important clause. Okay. The governing law clause. So what is the governing law clause? The governing law clause is a clause used in contracts where it is stated which rules and laws will govern the agreement if there's a disagreement or there's a dispute, or if a legal issue arises, which law will govern the agreement. First of all, every agreement must have a governing law clause. Okay. Every agreement, every contract, when you're negotiating a contract, when you're drafting a contract, you must ensure that there's a governing law clause. Okay, there's a governing law clause in the agreement. So this clause will determine which law we use to interpret or to resolve any dispute that would arise from the agreement. Okay. So the governing law clause allows the parties to agree what particular country's laws will be used to interpret and govern the agreement. So for example, the contract between Oluwaseyilay Limited and Taka Limited, the governing law clause could be stated as follows. So this is a typical example of a governing law clause. Okay. So governing law. This agreement shall be governed and construed in accordance with the laws of Ghana. So this is a simple governing law clause, a very simple and straightforward governing law clause. This is simple because let's assume that Oluwaseyilay Limited and Taka Limited, they are both in Ghana. So obviously they use Ghanaian law, even though they can decide to use the law of another country. But most times when the companies are both Ghanaian companies, they will use Ghana law. So as I'm saying, when both parties are all Ghanaian-owned enterprises or are all Ghanaian parties, then the issue of the governing law is not really an issue. That one, the parties would hardly have a lot of that. There will hardly be a dispute or hardly be a disagreement between the parties on the governing law. However, if one of the parties to the contract is a non-Ghanaian enterprise, then particular attention has to be paid to the governing clause. Especially when one of the parties is not a Ghanaian company or a non-Ghanaian enterprise. If both parties are Ghanaian enterprises, usually it's usually most of the time they will not opt for, even though they have the right to, but they will not opt to use the law of another country to govern the agreement usually. However, when one of the parties is a non-Ghanaian enterprise, then particular attention has has really paid to the governing law courts. And it's not, when you are drafting or negotiating a contract, do not overlook the governing law courts, especially when you are entering into a contract with a non-Ghanaian party. Do not overlook the governing law courts. You have to really pay particular attention to it. Because when there's a dispute, or when a particular provision of the contract has to be interpreted, it's done so in accordance with the governing law courts. So when you're negotiating or drafting a contract, don't just look at the price, the obligations, you have to deliver the goods, you pay this amount, has to be. No, you have to pay attention to the governing law courts. Because when there's a dispute, it will construe, the agreement will be construed in accordance with the law of the country. So for example, if Enedaso Limited, which is the Ghanaian company, enters into a contract with a company from, let's use a country we are not really familiar with. Let's say Guatemala. Okay, if Enedaso Limited, a Ghanaian company, enters into a contract with the Guatemalan company. Okay, and in the agreement, the governing law clause is provided that the agreement shall be governed and construed in accordance with the laws of Guatemala. Then it means that the contract will be governed in accordance with Guatemalan law. Enedaso Limited may not know anything about Guatemalan law, especially in relation to contracts or the subject matter of the contract, what the contract is about. Okay, if it's a contract for, let's say, the provision of furniture, if it's a contract for a specific item, let's say Enedaso Limited is an engineering firm. Okay, an engineering firm or a firm that's an architecture firm or something like that. The laws of Guatemala in relation to that subject matter may be completely different from how they understand it in Ghana. Okay, so when you are negotiating a contract with a company outside Ghana, you have to pay, especially if that party has given you the contract to review. Don't just look at the price of the contract, the amount you paid, how the amount you paid, and other things. You must pay attention to the governing law. Because otherwise, when there's a dispute, you find yourself wanting, you have to. The contract will be construed in accordance with the law of that country. In this example, Guatemalan law. And Enedaso Limited, the Ghanaian company, might not know anything about Guatemalan law. Okay. So it's very, very important that particular attention is paid to the governing law. Okay. Must pay particular attention to the governing law of the contract. Okay. And so these are some tips for governing law clauses. Do not just after, and I said this, I just said, do not just accept any governing law clause in the contract, especially one with non-Ghanaian party. Do not say that, oh, this contract, nothing will happen, nothing will happen. No. Pay particular attention to the governing law clause in the contract, especially one with the non-Ghanaian party. As I've already said, if there are two Ghanaian companies into a contract, that one, it is very unlikely that they will use the law of another country. Okay. Do not just accept any governing law clause in the contract, especially with a non-Ghanaian party. However, if you accept a governing law clause of another country, or if you accept that the contract should be governed in accordance with the laws of another country outside Ghana, then you must ensure that you are familiar with the laws of that country related to the contract and to the subject matter of the contract. You must be sure that you're familiar with it. Okay. As if you agree. And if there's a disagreement on the governing law clause during negotiations, the parties can decide to select a neutral venue. Okay. So let's say Enedaso Limited is a Ghanaian company. Let's say Takwa Limited is a Ghanaian company. Takwa Limited is negotiating with a company from Ukraine. During negotiations, the Ukrainian company would say, okay, no, we don't want Ghana. And Takwa Limited will say, okay, we don't want Ukraine anymore. What will happen? So, in order to satisfy both parties, the parties can agree that, okay, let's use a neutral venue. Let's use a neutral law of the country that we both do not belong to. We are not from those countries. So, for example, if Enedaso Limited, and this is not a real company, and TDK Limited from Sweden are negotiating a contract, and there's a disagreement on the governing law clause, the parties could decide to use the law of a neutral country. Okay. The parties could opt for, let's say, the law of England, for example. Opt to use the law of England as the governing law of the contract. Okay. And I'll say it again, it's very important. It's very important to look at the governing law clause. It's very important not to overlook the governing law clause, especially when the other contracting party is a non-Ghanaian company or is a non-Ghanaian enterprise or party. It's very important to pay particular attention to the governing law clause. Okay, so the next one is dispute resolution clause. Dispute resolution clause. At the time of entering into a contract or negotiating a contract, mostly in most cases, or in almost all cases, nobody enters into a contract for there to be a dispute. Most often, parties do not enter into a contract anticipating that there should be a dispute or thinking that there will be a dispute. However, there are always disputes. Okay? There are always disputes when it comes to contracts. So it's another very important clause is the dispute resolution clause. Okay, so what is a dispute resolution clause? Dispute resolution clause is a provision in a contract that sets out the mechanism in which disputes connected to the contract will be resolved. Okay. So if in the contract, for example, using our scenario, if in the contract between Mediation Limited and Takwa Limited, either of the parties fail to perform their applications, there must be a dispute resolution clause in the agreement that will expressly set out the manner in which the dispute has arisen to the parties will be resolved. Okay, so there must be a provision in the agreement which states that if there's a dispute between Mediation Limited and Takwa Limited, then the dispute will be resolved by A, B, C, or D. So there must be a dispute resolution clause in the agreement which set that out. Okay. There are various dispute resolution methods that can be used. There are various dispute resolution methods that the parties can opt for when negotiating such clauses. Okay. These include ADR. Okay, ADR to resolve their disputes. ADR is arbitration, mediation, negotiation. And Mr. Ojo would explain these to you. So this is just a summary of it. So it includes arbitration, mediation, negotiation. Or the parties can opt for litigation, that is settling the disputes at the courts. Okay. So all the dispute resolution methods have advantages and disadvantages. However, in recent times, there's a move towards using ADR to resolve this. That is what is happening nowadays. So when there's a dispute, instead of sending to courts, the parties would decide to do an agreement that the dispute should be resolved by ADR. That can be resolved by, there are so many ADR. Ones I've mentioned here, the most popular ones, arbitration, mediation, negotiation. The parties can opt to resolve their disputes using ADR. This is what people are moving towards nowadays. Okay. So, in most instances, litigating the courts has been the traditional method of resolving disputes. However, as we all know, I'm sure most of you have experienced the courts in Ghana. Most of us have experienced the courts in Ghana, and there are a lot of setbacks to litigation in Ghana. Okay. It's expensive, it's very lengthy, adjournments every day, and all that. Okay. And it also damages the long-term relationship with the parties. When let's say Mediation Limited has worked with Takwa Limited for a long time, let's say 15 years, if there's a dispute and it goes to court, it can destroy the relationship. It can destroy the relationship between those two parties. The litigation is very expensive, it's lengthy, very lengthy, it takes a long time. Okay. It takes there's a survey on how long commercial disputes, an average commercial dispute takes in Ghana, and it's more than 2 years. It takes a long time to resolve a dispute, commercial dispute in Ghana. Okay, so resolving disputes by ADR is advantageous. So I would advise a lot of you, SMEs, when you are drafting and negotiating contracts, for the dispute resolution clause, you must ensure that the dispute is resolved by ADR. And if you opt to resolve your dispute by ADR, there are some institutions in Ghana that can assist you to resolve the dispute. Those include the Ghana ADR Hub, the Ghana Arbitration Center. If one of the parties to the contract is not a Ghanaian company or enterprise, and does not want to resolve the dispute in Ghana, you can use the Lagos Chamber of Commerce International Arbitration Center, which is a well-known and a world-class arbitral institution or ADR institution that can assist the parties to resolve the dispute. Okay. The parties are also at liberty to make their own arrangements for selection. So the parties can decide that they'll appoint their own mediators, or appoint their own arbitrators to assist them to resolve their disputes. So we encourage the SME, we encourage you that when you're drafting contracts, especially the dispute resolution clauses, set to those clauses that it is a dispute resolved by ADR. Okay. All right. So the slides will be sent to you so you can read some of these. These are points when negotiating or drafting dispute resolution clauses. Okay. And one key thing is that don't assume that a dispute cannot occur. Never assume that a dispute cannot occur. Okay. Never assume that a dispute cannot occur. That one, don't say that, oh, I trust this party, so there can never be a dispute. No. If you do that, you're making a mistake. So you have to prepare for a dispute and ensure that the dispute resolution clause is well drafted. So let's look at dispute avoidance and prevention. When negotiating a contract, there are certain things that you can do that will prevent the dispute from happening in the future. Okay. So as much as possible, measures should be taken to avoid and prevent contractual disputes. Okay. So most parties, when they are contracting, do not intend for there to be a dispute, but when they are negotiating their contract, do not intend that there should be a dispute. But certain mistakes can happen during negotiation that can lead to disputes between the parties to the contract. And I'm just highlighting some of them. Okay. So these are some of the common mistakes made in contract negotiation and drafting that can cause commercial disputes. And the first one is performance before agreement. This is where the parties start to perform the contract before the agreement is finalized, and it happens a lot. Let's say, using the industrial scenario, let's say the two companies want to enter into an agreement to purchase furniture, but they don't wait, and one party starts performing. So let's say Industrial Limited pays money to Takwa Limited, and Takwa Limited supplies the furniture. When the agreement has not been finalized, do not do that. Okay, it's a grave mistake. Do not perform the contract before the agreement is finalized. Okay. Starting performance of the contract prior to finalizing the agreement can cause problems. So do not do that. Okay. So to avoid this, what the parties can do is that you can exchange drafts of the contract. Do not perform before the agreement is finalized, but prevent impatience, which is usually one of the reasons why parties perform before the agreement is finalized. It's impatience, usually in a hurry, or pressure from the other side. So to prevent impatience, the parties can exchange drafts of the contract so that as a review proceeds, the parties can reach compromises and narrow their differences. Okay, so do not perform the contract for agreement. The second one is failing to shop and compare. This happens when you need a particular service and you're in a hurry. There's a deadline that you have to meet. You just go for any company that you see. Failure to shop and compare can lead to unintended consequences. So it's prudent to send what we call request for proposal, RFPs, to different companies for performing a particular service, for them to detail what you want, the goods or services you want from those companies, what exactly you require. And an advantage of doing this is that if the negotiations stall, there's a fallback option. So it's prudent to do this rather than settling on any company at all. Okay. So failing to shop and compare can ultimately lead to disputes. If you're in a hurry, and you have to meet a deadline, you have to meet a target, you have to contract with a particular company for goods or a particular service. You just give it to any company, it can lead to disputes. Okay. So if you send out the request for proposals and the companies bring out their in the RFP, it stated what you want, what the company should do, and all that, and you're able to select. If negotiation one of them fails, you can get another one. That will assist you into a very good contract. The next one is failing to describe performance obligations properly. Performance obligations, that is what the parties are supposed to do in a contract, must be stated expressly in the agreement. It must be clear, it must be unambiguous in the agreement. Okay. And you must ensure that the obligations for the parties are in writing, not orally. So no matter how you believe or trust the other party, you must insist that the obligations for the parties are in writing. It shouldn't be oral, it must be writing, it must be documented, it must be clear for everyone to see that party A is supposed to do this, party B is supposed to do that. Okay. If you fail to detail the performance obligations of the parties, there's poor performance, the other party doesn't perform their obligations, then it means there's no breach because they haven't breached anything in the agreement. So it has to be in writing. And do not rely on trust or belief, that this party will do it, will do it. No, it has to be expressly written in the contract. The next is weak vetting of suppliers and vendors. When you are choosing a vendor to enter into a contract, you have to do due diligence. You have to ensure that they are not fraudsters, okay, but they are not incompetent. So you have to do due diligence. Failure to do due diligence might lead to disputes in the future. Okay, so you have to look out for red flags, such as pressure to sign a contract. Sometimes other parties say, oh, let's sign, oh, the rest, we'll talk about it later. Let's sign it right now. Let's sign the contract, we'll talk about it later. No, do not accept that. That's a red flag. Or if the other party is unwilling to put a particular term into writing, that is also a red flag. Those are some of the red flags you have to look out for. So you must do your due diligence of the other contracting party before you enter into a contract with that person. The next one is accepting contract terms blindly. Sometimes when you are dealing with some companies, entering into contracts with them, they'll give you a draft. We have drafted it already. We have drafted it already, so let's sign it. Let's start. No, don't do that. You have to make sure that you review every single line in that draft agreement, okay? Because there may be provisions that will be detrimental to your company. And do not succumb to pressure from the other side or the other contracting party that, oh, they ask for this money, stick to leave it. You can't review anything in it. Don't accept it. It happens a lot. You have a contract from another party and you say that, for this one, we don't change our standard agreement. Do not accept that. Do not accept tickets or leave it standard terms, standard agreements. Make sure that you can review it and change anything that is detrimental to it. If the standard contract is not acceptable, okay, you must insist that there must be changes. If the party doesn't agree, then it's advisable to look for another service provider. And this happens a lot. We give you the standard contract and say that we don't change anything. No, insist that there must be changes. So even if there's something detrimental to your company, you can change it. The last one I'll talk about is not properly tracking or proofing documents. This happens especially where parties exchange drafts, usually by email. The agreements will be track changed. What happens is that if I have an agreement, if you send me an agreement, let's say Abraham sends me an agreement, I look at it, I make my track changes, I send it to him. He do his and he bring it back to me. when the other side, when the other contracting party sends you the agreement with exchanges, ensure that you compare with what you have sent before so that other clauses are not smuggled in. Something is not changed without you knowing. It happens all the time. So you must properly track and prove documents. It takes a bit of effort, but it's at the long run, it can prevent a dispute. Okay, or it can prevent something that you do not intend to put there. But a change of one word or one figure can change a lot of things. You must be very, very, very meticulous in that. Once, especially when the drafts are exchanged by email, it's sent back to you. You have to compare what you sent before and ensure that it's the same thing and nothing has been smuggled in or taken out. Or nothing has been added to without your knowledge. So the last, we're almost done. The last one is navigating regulatory issues. This one is very, very short. So there are various categories of business entities in Ghana. We have sole proprietorships, partnerships, companies, and SME can be a sole proprietorship, it can be a partnership, it can be a company incorporated. Okay. So when drafting or negotiating contracts, it's necessary to know the kind of business entity you are dealing with. So for sole proprietorships, that is, we usually call it one-man business in Ghana, one woman or one-man business in Ghana. The owner signed a contract in his or her own name. Because a sole proprietorship does not have separate legal identity under the law. A sole proprietorship, the business is not separate and distinct from the owner. So when there's a dispute between the sole proprietorship and another entity, there's a liability. It's the owner who will be personally liable. Okay, because the sole proprietorship doesn't have legal personality. It's effectively the same as the owner of the company. You must note that. Owner of the business, you must note that. But when it comes to companies and partnerships in Ghana, Act 152, that is the Incorporated Private Partnership Act and the Companies Act, provide that once such entities are properly registered, they have separate legal personality. That is, the companies become artificial persons. That's the technology. Become artificial persons. They can buy and sell property. They can sue others. They can sue them. They can be sued. They have capacity to enter into contracts in their own name. And of course, subject to various provisions contained in those acts. So if you're contracting with a company, the company has capacity to contract in its own name, to enter into contracts in its own name. But for a sole proprietorship, the proprietor or the owner of the business is not separate from the business. If the business is a liability, that person is responsible. But for a company, there's a liability. The company, because it has capacity to do that, to enter into the contract, will be liable. That's subject to various exceptions, but this is the general rule. The next one is illegal contracts. That's the final point to make. Illegal contracts. When you're drafting, negotiating a contract, you must really take care that the subject matter of the contract or an obligation of the party under the contract or the terms of the contract are not prohibited by law. If the subject matter of the contract is prohibited by law, it becomes an illegal contract. Okay. And illegal contracts are void. It cannot be enforced. They are void. And we treat it as if there was no contract in the first place. So you can't enforce an illegal contract. If you pay money towards the performance of an illegal contract, you can't recover it. So you must ensure that the subject matter of the contract or the terms, obligations of the parties under the contract are not contrary to any law in Ghana. If it's contrary to law, it becomes an illegal contract. You cannot enforce it. If you pay money, you cannot recover. You cannot sue to recover the money in the contract. So the examples of illegal contracts are employment contracts that permit hiring of underage workers, agreements made for illegal activities such as prostitution, contracts for the sale of or distribution of controlled substances. This is not an exhaustive list. It goes on and on and on and on. So anything which the law prohibits shouldn't be the subject matter of the contract. If it's so, then it becomes an illegal contract. It cannot be enforced. Okay, so thank you very much for listening. Thank you very much for listening. Take any questions. Thank you very much for listening. Abayomi, are you there?
Thank you very much, Kenneth. Do you want to quickly answer the few questions that we have here? There's a question on insurance for risk. Um, do you want to answer that question on insurance and risk? Then I think
Okay.
maybe leave the ADR question for Mr. Ojo.
Okay. So let me take the ADR. Abdullah Bashir is asking now, what if there was no ADR clause in the contract and the parties agree later to use that method to avoid litigation? Okay. So it depends on what is in the contract. If the contract states that if there's a dispute, be settled by the courts of Ghana, and that one there's no escaping it. There's no then the dispute will be resolved by the courts. Okay. Resolved by the courts. Unless, of course, what happens sometimes is that when the case is sent to court and both parties agree, then the court can grant leave for the parties to try to resolve it by ADR. But that one, if the other party doesn't agree, will not happen. Both parties have to agree. So when you are drafting a dispute resolution clause, you want the dispute to be settled by ADR, you must expressly state that the dispute should be settled or should be settled by ADR, using ADR. It must be expressed. Okay. And one thing must also that some people have the tendency to combine court and ADR. That is not a properly drafted ADR or dispute resolution clause. Either you're going for ADR or you're going for litigation, but we advise you to go for ADR. So in this case, you must put into the agreement that the dispute will be settled. There's a dispute between the parties arising out of or in connection with the agreement or the contract, then the dispute should be settled by ADR. Okay. And then the next question by Abdullah, about the insurance for a risk between the parties. What if the anticipated risk does not happen? Then if it does not happen, then the clause will just be there. The clause will be activated when what is anticipated happens. Okay. So if nothing happens, then there'll be no need for that clause to be activated. Okay. For the insurance, it's like when you take insurance for your car and all that, most of the time nothing happens, but you still have to take the insurance anyway. So that's the same way for the contract. It will be activated when the particular thing happens. Okay. When the particular event occurs, that will necessitate the insurance clause to be activated. I hope I've answered your questions.
Thank you very much, Kenneth. Thank you for that very insightful and informative session. I can see Mr. Joseph Amuzu raising his hand. Joseph, do you have any question? Joseph. Okay, right. So we'll move swiftly to the next session by Mr. Sheila Ojo. Just a quick background about the next speaker. Mr. Ojo is a legal practitioner and senior partner of SO and C Legal, a law firm located in Lagos. His experience cuts across transaction documentation, litigation, and ADR, particularly in the areas of corporate, commercial, and international business law. Mr. Ojo has attended and distinguished himself in courses both locally and internationally. He's an alumnus of the Academy for American and International Law, which he attended as a recipient of the 2004 Victor Folsom Fellowship Scholarship for Africa. He has also appeared before the various tribunals, private and governmental, as well as trial and appellate courts in Nigeria. He is a notary public for the Federal Republic of Nigeria, obtained his Bachelor's of Laws degree from Obafemi Awolowo University in Nigeria and Master of Laws degree in International Business Law from University College London. He also holds 2 international business practice diplomas in international business organizations and international M&A. Mr. Ojo is one of the most sought after ADR practitioner and trainer in Nigeria, and it is indeed a privilege to have him speak to us today in this session, ADR section. Mr. Ojo, you may have the floor now.
Thank you very much, Abayomi. Good afternoon, ladies and gentlemen. Excuse me. Thank you very much for this opportunity to speak virtually from Lagos to participants in Ghana. I must thank Kenneth for the work he's done, because sincerely, I know it is very, very heavy, and it was no mean feat putting together these many slides. And I know that it might sound very heavy to you all, but I am also confident that at your own times when you retire home, you can look at the slides and put them in perspective. And as you look at the slides and reflect on the things that Kenneth has shared with us all, I'm fairly confident that it will be more and more, it will be more impressionable, even together as we go through it. So thank you very much, Kenneth, for that. Abayomi, I say thank you for the glowing introduction. But at the end of the day, my name is just Sheyi Ojo. I am a lawyer and I practice ADR. I am an ADR advocate. And it's a privilege to have to speak with you. That the time that I will spend sharing with you, the few minutes I will spend sharing with you, I might be able to discuss with you matters that are relatable, the things that you encounter in your day-to-day business dealings in terms of disputes arising and how you're going to resolve the disputes. I'm also hoping that not only will you find it relatable, I'm hoping that through this session, you will be able to pick up on a couple ideas on how maybe to improve steps that you had taken before, maybe offers that you have made. So we're going to talk mainly about the concept of ADR. I noticed that the last question was that can parties go to ADR to avoid litigation? We'll answer those questions here. We're looking at the concept of ADR. What is ADR? What are the forms of ADR, alternative dispute resolution? Our main focus in this brief period will be mediation, negotiation, and mediation. We're going to look at the nuances of negotiation in particular, because negotiation is the core of mediation, because mediation is, only put differently, assisted form of negotiation where parties get somebody to assist them. But we're going to look at those two as opposed to all other forms of alternative dispute resolution. A training on the forms of alternative dispute resolution can hardly be contained in a 1-hour session. The reason is simple. I did a mediation skills course in, I think it was 2011 or 2012, and that was a full week, 6 days to get that training done. So if I was to take you through it, you will find out that it might be a bit burdensome on you. However, being business people, I am fairly confident that what I will discuss with you are matters that are relatable, that you'll be able to pick and choose, take a cue from in terms of managing your disputes that arise in the context of your business dealings. So I want us to first of all reflect on what we're looking at on the screen. Peace is not the absence of conflict. It is the ability to handle conflict by peaceful means. All of us who are participating in this session are business people. Business, you will always have conflicts, because when you're dealing with another person, obviously interests will sometimes clash. So you want to ask yourself, when this thing comes, how do we resolve it? Do we fight and throw caution to the wind, or how do we go about it? But I want you to also understand where ADR comes from. Conflict is something that will always exist. So it is not peace is not the absence of conflict, but the ability to handle it by peaceful means. That is what it is about. So what is alternative dispute resolution? Alternative dispute resolution is a procedure for settling disputes or conflicts without litigation. And I emphasize without litigation, such as arbitration, mediation, or negotiation. Without litigation does that mean that if we are in litigation, we cannot deploy ADR? Certainly not. What you're basically saying is that we're in litigation, but we want to resolve it without litigation. So you will step out of the courtroom to find an alternative way to resolve the disputes. But let us understand what exactly it is we want to resolve. What is a conflict? Like I said earlier on, a conflict will arise when the interests are not compatible. Because as men of commerce, as people of commerce, we always have divergent interests. And these interests sometimes will clash. So it is inevitable that we will have conflict. There are friendly conflicts that you have sometimes, and there are non-friendly conflicts, obviously, that you also have. Now, Max Lucado says conflict is inevitable, but combat is optional. So, if you have conflicts, how would you resolve the conflict? That is the question that you want to ask. But let us also make a distinction between conflict prevention and conflict avoidance. A lot of people talk about, oh, I'm trying to avoid I don't want to have any conflict with this person, so let me just do it this way. That you will find is wrong. Because conflict avoidance, if we are agreed that conflict is inevitable, it means that conflict will come. So we must, first of all, learn to embrace conflict, because out of conflict births good virtues as well. Because it's like gold going through fire. It must be refined. It can only be refined when it goes through fire. So use conflict as an opportunity to have a better result in terms of your relationship with this person or this other entity in contract, and perhaps even as individuals. Conflict avoidance is where you are trying to pandy to people just to make them feel good and say, oh, I don't want to fight, and you are shying away from discussing the issues. The problem with conflict avoidance is that you're going to reduce yourself to a doormat. And the things that you ordinarily find objectionable, people will assume that they go well with you because you do not talk about it. Talking about it is confronting conflict, which is really what your remit should be. Conflict prevention, however, is the very essence of what Keneth has just discussed with you all. Conflict prevention is doing everything to ensure that there is no conflict at all. In other words, conflict avoidance is when conflict has arisen and you are shying away from dealing with it. It is not going to go anywhere. Conflict prevention, however, is trying to keep it at bay so that your relationship with this contracting party remains cordial. So what are the forms of ADR? Negotiation, mediation, we'll talk about that in a minute. Arbitration is the next level. So I've put the three that way because negotiation occurs between both parties alone. It is actually your first and your most parties is your default mode. When you have a dispute with somebody, you pick a phone and call the person and discuss it first. Depending on what is going on, some people will go over the top. Some may not. At that level, it's possible to actually resolve that dispute. Then there is mediation. Maybe emotions have ridden high, but both parties are at the very least agreed that there is a need to resolve this conflict. But they cannot do it together because maybe the issues are murkied up, maybe because the emotions are riding too high, they cannot see eye to eye, maybe because of one person's general behavior being obstinate and being unreceptive by the mere sight of the other person. So you get a third party neutral to assist in helping you resolve. So that third party neutral is just coming to help you negotiate. He's assisting the negotiation process, and that is mediation. Arbitration comes into play where, for example, it is not possible to resolve it by mediation, and then you require taking the dispute to a third party to now give a decision. The interesting thing about negotiation and mediation is that whatever decision is reached following those two processes are decisions made by the parties themselves. And it is often encouraged because where the parties themselves come to these decisions, the Americans are wont to say the devil is in the details. There are those little things that do not find their way onto the black and white dotted lines of a contract, but which are actually the things that drive a contract. They might be emotional, for example. Now, when parties through mediation and negotiation come to agreements, invariably, they will find themselves implementing the agreement better than if a third party slams on them what the interpretation of their agreement should be, which is where they have to go when it comes to arbitration. But then arbitration does not just slam it in like that. It also involves a third party neutral who is invited or chosen by the parties to help them determine their dispute in a much more convivial or a much more friendly environment, as it were. It wears a semblance of litigation because at the end of the day, there will be a winner and there will be a loser. But it is still there. You'll be spoken to. Somebody who's going to, about me, I think, is going to talk to you about arbitration and you'll fill you in more on that. Now, there is conciliation. Conciliation is akin to mediation. It's just that in the mediation room, the party, right, the mediator does not take a decision for the parties. The parties themselves take their decision. In the conciliation room, however, the conciliator is more proactive. His objective is to make sure that the parties reach an agreement. That is not the objective of a mediator. Now, you find the Ghana Arbitration Act 2020, which we'll talk about in a minute, makes provisions for mediation. Even in Nigeria, what we find is mediation, even though our existing framework talks about conciliation. Now, then there is MedHab. MedHab, clearly, as you would see it, is a hybrid that includes a bit of mediation and a bit of arbitration. So take, for example, you have 5 issues to contend, and you go to mediation with the 5. At the end of the mediation, you could only resolve 2. The remaining 3, you need a third party to tell you which way to go as far as that is concerned. So that process then translates from mediation to arbitration. And there are institutional bodies that help you administer this, or the parties themselves can choose. You can even say that the mediator can be the arbitrator. But in a lot of cases, they will say the mediator should not be the arbitrator because of the kind of information that the mediator has gathered through the mediation process that might bring a coloration to his thinking on the issue. And then there's lastly the early neutral evaluation, which again, you may find this in the context of construction disputes. You have a dispute that is an ongoing construction that is going on. And as you probably are aware, for those of you that are involved in construction work, you will notice that you have equipment on site. So everything is per diem. You have X amounts that you are incurring every day the work is not going on. You have penal charges that are going to be incurred. So sometimes you find out that if there's a dispute in relation to that contract, it is difficult to say, it is not commercially expedient, if I can put it that way, to take that dispute to an arbitration hearing. Because as much as it is intended to still be fast, it might not be as fast as it should be for you. Now, early neutral evaluation occurs when, for example, a dispute arises on a construction site, and it doesn't have to be construction, by the way. A dispute arises and both disputing parties refer the matter to, let's say, an expert, let's say an architect, since I'm using construction as an example. take it to an architect and give a decision, evaluate this and let us know what your thoughts are on it. So he listens to both sides, and within a short time frame, maybe even a month or less, he comes to a decision for the party so that they can go on. That way, the costs that you incur for the downtime becomes minimal. So when you compare that, so you have to know which cap you want to wear at any one time. I practice as a litigator, I practice as a mediator, I practice a lot in the arbitration space. In fact, that's where most of my experience has been. And what I find is that when I sit down to advise clients, sometimes the story is being told to you, but what you're seeing is different because I wear the different hats at different times and I can see things looking differently. If somebody is looking for litigation, meanwhile, what you should really do is call the person into a room to negotiate. So negotiation and mediation, I've put two definitions there for you. Negotiation is a dialogue between two or more people or parties that is intended to reach a beneficial outcome over one or more issues where a conflict exists with respect to at least one of those issues. Like I said to you, you may have a situation where not all the issues are in contention, or you have all the issues in contention and only one of them is resolved. Mediation, on the other hand, is a process in which a neutral third party assists disputing parties to work towards reaching a negotiated agreement in settlement of the dispute. So you will see that negotiation itself is at the core of a mediation exercise. Negotiation is at the very core of mediation. Mediation is only a third party assisting the parties to negotiate. So those things that form and create mental blocks that prevent them from coming to an agreement, those things are the very things the mediator helps to move. The mediator sieves the wheat from the chaff and helps the parties to come to an agreement that they themselves reach. So let's talk negotiation first of all. Now, you and I know what negotiation is about. So you want to go to the market to buy something in the market, you're going to banter left, right, and center. You're going to say, look, how would you accept this amount? I remember when I was in, I think I traveled to Ghana on Christmas one year, and my wife and I went to, well, I think it's called Osu, I think. Forgive me if I'm wrong. I know I can't get the feedback. But we went to buy wooden fabrics, and I was a mad lover of wooden. And I noticed that, we were bargaining. And so it's not peculiar to Ghana. It's everywhere. As long as you're a man of commerce, you're a woman of commerce, you're a company of commercial activity, even NGOs, you still need to negotiate issues with people. So you will find yourself negotiating. The question then is, how do you negotiate? So there are three identified models of negotiation. I'm privileged to have been taught by the gentleman whose name is there, Oluwaseyilay, in a course. And he, in his research, identified these three models: negotiation as a compromise, negotiation as domination, and negotiation as joint problem solving. As we discuss these models briefly, I am fairly confident that you will be able to say to yourself, somebody has used this on me once before, or I have used it on once before. More important, and what I'm hoping that you'll be able to get out of the process, is that you will see which one is best suited to your needs, but more importantly, you will see how real negotiation should be and how and when to take certain steps in regard to negotiating with the parties. So negotiation as a compromise. So I have a diagram there. You see where both parties A and B stand and how they're moving towards that center. It is otherwise referred to as distributive bargaining. It results in a win-lose for the parties. Win-lose not in a necessarily bad way, but win-lose because there are quite a few, it comes by way of concessions. You reach a compromise by making concessions. So I leave this, you leave that. I leave this, you leave that. I leave this, you leave. So they begin to make those concessions until they get to a common middle area where they probably can work to agree. To the extent that one person makes a loss of something he would have gained from, it is in that context that you hear you use the word lose, because you're gaining here, but you're losing on another level. So, but the agreements are reached by concessions. And as I said, there is that single pie that they want to divide. So they struggle very hard to divide it. The difficulty sometimes with this mode of negotiation is that the fact of a loss on an issue that may otherwise have been important to you, but which you reluctantly had to make a concession on, sometimes lurks in the horizon. So in your dealing with the party later, you may find yourself in a situation where it comes in and you're not going to let go this time. I let go the other time, I don't want to let go the other time. So it still can be a challenge. That's one of the disadvantages that you have with that form of negotiation. Then, of course, negotiation as domination. Small and medium scale enterprises, as Abayomi reeled out the statistics in his opening remarks, he talked about in Ghana, for example, they form, I think, Abayomi, correct me if I'm wrong, 85% of the GDP in Ghana. Now, if 85% of the GDP SMEs are responsible for it, these are small and medium scale enterprises. Of every country has a definition for a small and medium scale enterprise. But in Nigeria, for example, it's defined by reference to a 5 million to 50 million naira assets turnover. So if you're looking at that, it is still very small. And these small entities run the economy. Why is that relevant when I'm talking about negotiation as domination? It's simple. Most of you will at one time or the other have dealt with big organizations to whom you can't seem to get a word in. What they say is always law, yet you know that they're taking undue advantage of you. How do you negotiate? Most of the time, and I'm using big organizations not because I feel they dominate, but some big organizations are very ethical in spite of their size and power, but some are not. But no, big organizations, I'm using them symbolically to mean anyone who feels he has an upper hand in a negotiation. So such a person deploys power plays and dirty tricks to force an agreement on you. So in this diagram, you see A is at the top, B is at the bottom. So A is the dominant party who is dominating and shoving his idea of what a deal should be on B. Now, the sad and sorry reality of it is that this form of negotiation results in a situation where the dominant party takes the bigger chunk, if not all, of the fixed pie. It is combative. It is very combative. I'm sure most of you would have picked the phone one day and said, look, we're not doing this. This is the company policy. We're not going to do it. If you don't want it, please let us know. We have other suppliers. We're not ready to talk to you. You should be able to forego this. They are wrong. They may be the ones that are wrong, but they say you just have to forego it. We have to go this way. So again, negotiation as domination, what does it result in? It is a variant of the first model in the sense that the weaker party will make painful concessions. So you still have a win-lose result to it. The third form is negotiation as problem solving. Obviously, this is a joint problem solving. I mean, this is where, in terms of negotiation training, this is where I encourage all of us to be. This is where all of us are encouraged to be. Why? For the simple reason, we always part to meet again. We finish this deal, tomorrow we're going to meet deals. Nowhere else does that pan out as much as, for example, in legal profession. As lawyers, and I'm speaking to my colleagues now, today we're on opposing sides in court. Tomorrow we're on the same side, representing an interest. So we must be able to look at the dispute beyond the moment. So this is generally considered to be an interactive and interest-based bargaining mode. So parties see themselves as coming together to jointly solve a problem. A takes B's problem as his problem, not that he's going to begin to wear B's shoes, but he begins to look at it and tries to understand. Now, the reason this is very unique is that both parties, either party is going to do his bit to understand where the other person is coming from. And that gesture will typically be reciprocated. And then they begin to look at it and say, what exactly is it that we want from it? I told a story about two daughters, and this is a true story. Two daughters to whom a man bequeathed his entire estate. He was a very, very wealthy man in New York. And he bequeathed his entire estate. And these children, both girls, got their fair share as directed by the man. They were both happy, except for one thing. The gentleman had a ring, and both could not agree as to who should take the ring. So a fight, a debate ensued, and it became messy for them. Either one of them wanted the ring until one woke up. Let's say for purposes of our discussion, A wakes up one morning and says, look, what's going on? All right. Calls B and says, why do you want the ring? Why do you want the ring? And he says, oh, I just want the ring because there is a pendant on the ring that I like. Oh, it's because of the pendant. Yes, okay, you, why do you want the ring? Oh, I want the ring because of sentimental reasons. I just want you to remember Daddy Bye. Said, oh, so at that point, they realized that their interests, however different they may have been, were not irreconcilable. Because the one who wanted the ring because of the pendant was given the pendant. And the one given the pendant went to her childhood gifts and saw a pendant that looked alike and put it on it. So both of them could still say they got value for their late father's estate. That is what it is when you're talking about interest and interactive and interest-based bargaining. They seek a deal that integrates interest into a well-crafted agreement for them. They recognize the extent to which interests are compatible. So their interests, they start from the default mode that our interests are compatible. But even if they are not compatible, as in the case I just explained to you, they are not mutually exclusive. It is still possible to find a common ground with those interests. Now, this last model is what actually, pardon my play on words, this last model is what actually models what you call principled negotiation. As defined, an interest-based approach to negotiation that focuses primarily on conflict management and conflict resolution. Principled negotiation uses an integrative approach to find a mutually shared outcome. To find what? A mutually shared outcome. So, but it is rooted on certain foundations that must coexist. One, you must separate the issues from the problem. So the two sisters left themselves. Maybe one was being obnoxious, the other was being rude. Let us leave that alone. Let us focus on the interest. So they've left themselves, they've identified that the problem is not themselves. Now let us look at the interest. It is not the fact, looking at the interest and not positions, by the way. So I want the ring, I should have the ring. I took care of my father the most. You want the ring, you should have the ring because you want to be sentimental about it. No, those are positional issues. And one of the things you learn about principled negotiation is to avoid positional bargaining positions. Pardon my words, I'm playing on words there. Positional bargaining, yes. You need to avoid positional bargaining. So focus on interest, then invent options for mutual gain. Inventing options for mutual gains is what the girls did when it came to the ring. Then insist on using an objective criteria. So sometimes if you are in a pricing situation and you say you're going to collect X amount, the other person says, no, I can only pay Y amount. in using an objective criteria, you might look for a standard that both of you generally subscribe to. If you have a standard that both of you subscribe to, typically, once you are in unison on that, you are more likely to operate within what you call a zone of possible agreement. And we'll talk about that very soon. So you are using an objective standard to come to that zone where you can negotiate that way. So we need to prepare for negotiation. When you consider that it is possible for you to be emotive, it is possible for you to be angry, it is possible for you to have the big fish, small fish thing where the big fish wants to swallow the small fish. You need to understand that negotiation is not impossible. That you have a big fish, small fish situation does not mean that you should now avoid conflict. No, it means that you need to prepare to negotiate out of that conflict situation. So whenever you're in conflict with someone, there is one factor that can make the difference between damaging your relationship and deepening it. That factor is attitude. So it is said often that attitude is everything. I'm sure you must have heard somebody say attitude is everything. John Maxwell, who is a renowned writer on leadership, always says that your attitude determines your altitude. A plane can only fly because it goes against the direction of the wind. That's how an eagle flies. So you will find resistance. But how do you ride on that resistance on account of your preparation? This is what we want to talk about next. So first and foremost, determine what you want from the negotiation. Do you want a contract or do you want a relationship? Some of us are SMEs servicing very, very big multinationals. They're providing support services to multinationals. Just like in the oil and gas sector, you have the big players, you have the Mobiles of this world, you have the Chevrons of this world, but then you have those oil servicing companies that are there. If it is a car manufacturer, for example, it will also have spare part dealers and spare part manufacturers and all those things that probably are servicing them. So a Coca-Cola International, however big it is, will typically have its own suppliers, those with whom it has constant supplies that it will give LPOs, local purchase orders, regularly for certain supplies. So what do you want? Do you want that singular contract or do you want a relationship that lasts? So if your bargaining is dominant, is more dominatory, and you know that this entity that you're dominating provides quality products to you, do you want to negotiate that company out? Because once that company gets a bad deal, it will do this deal, but walk away from your company and go and perhaps go meet somebody where you get better value and become a big company itself. Organize your team. Know who are relevant. Incidentally, the Ghana ADR Act actually makes a point that there are some people that you should not even take into a mediation room or into a negotiation room. If the person, in fact, it says that unless both parties and the third party neutral consent, we'll talk about that when we get to mediation. But unless there is that consent, but don't just take your family members. It's not a courtroom. Who is relevant for that meeting? Determine. Define your interest and think about the interest of the other side, the same way those girls did. What exactly is this person thinking about? Why does this person want this from me? Identify the issues, narrow it down very well. There is something called the best alternative to a negotiated agreement. We will get to that next. But think of the best option available to you. So if you do not reach an agreement, what are the options open to you? You look at the options that are available and take the best of those options. That is what you refer to as the best alternative to a negotiated agreement. Then think a lot about the other party. Research the other party. The wonders of Google. The wonders of Google is critical. And I'm going to tell you a story where we come to BATNA now about researching the other party. Then formulate mutually beneficial proposals in advance. That's what we just talked about. So when we talk about a BATNA, what is the BATNA? Simply put, it is the standard against which any proposed agreement should be measured. So if you sit down and do an evaluative process, like I said, you have looked at the options open to you. You have seen that of the 3 or 4 options that may be open to you, option 4 is the best, and you have taken that option 4. In taking and evaluating option 4, you would have looked at where option 4 is going to take you, what you're going to get from option 4, and how option 4 is going to help you compensate for the loss you're suffering on account of a failed negotiation. That is what it means to have a standard by which a proposed agreement should be measured. We will see in a minute what your partner will do for you. The partner is, put differently, the balance between you rejecting an offer that you ought to accept and accepting an offer that you ought to reject. So if you go to a negotiation without proper preparation, you wouldn't know when you should say no. You wouldn't know when you should say yes. All you have done is that I'm not going to come lower than this, and that's it. Sometimes I'm not going to go lower than this amount. Might require you to think more about the options open to you if all you can get is a shade lower than that amount. If all you can get is a shade lower than that amount, then your partner versus your bottom line. So your bottom line, or as they say, the WATNA, that is the worst alternative to a negotiated agreement. So of those options you've looked at, of those many options that you have considered, now you've taken option 4 as the best. Perhaps option 2 is the worst. So option 2 is the minimum you will settle for. The minimum, once you see that, that is your worst alternative. Now that becomes relevant sometimes where you have a deadlock and you are refusing to yield to something. That option, that WATNA, is your reality check. It is one of those things that tell you, don't be just too difficult and needlessly contentious about these issues. So that is one, those are the things that you need to know about your partner. But how do you develop it? We've talked about it already, so I'm just going to gloss over it. But a note to self, the purpose of negotiation is for you to have a result that is better than what would have been the case for you if you did not negotiate at all. So there is no point going into a negotiation without following an evaluative process to know exactly what your options are. I'll give you a quick story. There is a negotiation between a Malaysian entity making certain products that are required in the US, which US is paying top dollar for to get from within the US. But getting it from a Malaysian company is much cheaper. Somebody in the US entity has gone to Malaysia and has researched this small mushroom company, inspected its services, seen that it has all the equipment and can produce the number that they want. Can they produce it as often? They may not be able to. So they have this sit down to discuss the purchase. And now they reach, we want to sell for $160 a unit. The US company, they want to sell for $160 a unit. The US company says, nope, we're not going to pay more than $140 a unit. Now, the Malaysian company is saying to himself, how will I take this? We can't settle for this because what is the risk that I am taking? We're a small company. If we're going to service this US entity, that means that we're going to have to expand so that we can meet all the orders. So if we produce at 140, we might be able to do that. But what happens if they decide to blacklist us and they don't want us anymore? We'll just have waste assets. The US company looks at the Malaysian entity and says, wow, well, these guys are insisting on 160. This is what is going on in their minds. What value proposition can I make to make it attractive so that I can come down lower? Now, then at that point, the US company says, all right, look, rather than say we are paying you 140, All right, we'll pay you this 140. However, we know that you want to get into the US market as well. There is a fair that is coming up. We have a huge stand at that fair. We will allow you a place to display your own wares and to have a voice using your products at our stand. Clearly, that Malaysian entity is saying to himself, oh, this is free advertorials for me without me paying. There is a value proposition. Now, if you do not research very well and prepare yourself for the negotiations, these little intricate parts that are coming out, you will never see them. You will never see them. So you're just stuck to the bottom line. I'm not going to take anything less than 140. And even when, I'm not going to take anything less than 160. And even when 140 should be attractive to you because there is something that is going to cushion the effect of that 140, such that if you lose that company tomorrow, you get another company through that effort. You're not seeing it because you're so fixated on that bottom line that you're not going to move forward. So invent and consider a list of available options. We've talked about that. Evaluate, improve those options. Look at where they're taking you to and look at what you can get from them. And then select which of the options is best of all. That is developing your partner. What is the benefit of it? Realistic assessment of the consequence of failure. It builds your confidence. It builds your confidence. I tell my colleagues that when we go to court, that the time I feel the most confident in court is when I have read my files. Because information is power. Once you have information, it is difficult not to have answers to every issue that comes up. Knowing the partner of the other side helps you also determine the extent the other side is willing to go. I say here that it also helps you define an amicable and efficient settlement. Now, what do I mean by that? Do you know, it is very possible that parties go into a negotiation and do not agree and have to walk away from the deal. But then, in walking away from the deal, they are still very good friends. How does that happen? If both parties have researched their partners very well, and the partner remains the standard against which every good agreement is going to be assessed. Now, when you sit down and you see that the agreement that is being offered to you, measured against your partner is better than the agreement, and the other side sees the same thing as well, then both of you will come to a mutual understanding that, oh, this relationship is we just have to agree to disagree. At that point, you walk away, you are amicably walking away, and the process has been made efficient because the relationship is also preserved. So it is not unlikely that tomorrow you're going to come back and you can do business, and that time cross your T's properly and dot your I's well. Now, what are the key elements that you need to be mindful of when you are going into a negotiation? Communication is very key. It is very key. Listen actively and listen to understand. When I'm listening actively, it's not that I'm just looking and standing, or I'm standing akimbo. No, listen actively. Take it in. Don't interrupt. Let the person speak, because the more you interject or the more you are dismissive, and all of us, the best of us are guilty of this. Somebody is speaking, no, please, don't say that, don't say that, I will not agree. No, you have got it all wrong. No, listen. Take it all in. And then process what you are being told, because that way you are communicating. The person who is speaking knows that what I am saying is being taken. And he feels that comfort knowing that he has been able to vent or express himself. Don't just listen because you are trying to frame a response, because that is another error we make. We're just, have you finished? Have you finished what you're saying? Have you finished? No, just listen. Do not make insulting offers. I talked about the zone of possible agreement earlier, and we'll go to it in a minute. So don't just make insulting offers. Don't throw caution to the wind when you're going to make an offer. Stay within your zone of possible agreement and use that also as a benchmark for your offer. Like I said, we'll talk about that very often. Now, speak to be understood. Now, just as you expect the party on the other side to listen and not only listen, but listen to understand, so also you who's speaking must ensure that you speak so that you can understand, so that you can be understood. Now, very often we can be abrasive. Talk to the person, don't talk at the person. 10% of conflict is due to difference of opinion, and 90% is due to your tone of voice. If you're raising your voice at me, I'm going to ask, why is he shouting? We encounter these things every day in a normal entity, in our normal business lives. So speak to be understood. Avoid name calling and inflammatory remarks. Then create an enabling environment for negotiation. Seek as much privacy as you possibly can. Like I said, you don't just take everybody into the room because you want them to go there. Ensure that only the relevant persons are in attendance. Speak about yourself. I'm not talking about an ego trip now. I'm not saying I am professor of this, I am chairman of this, I own this, I own that. No. Let's focus on the problems and the issues. You're talking more about how the issues has affected you, or as it were, affected your business operations. That is what you're talking about. Leave the other side to its own. Do not condemn people's motivations. I know this is why you are doing this. No, do not condemn their motivations, because you may not even know what their actual motivations are, and don't blame them. Speak for a purpose. Do not be flippant. Sometimes our crime is that we over-communicate. Let me give you this anecdotal story. This is a true story. Now, I'm sure most of us have heard of Mercedes-Benz. So we all know Mercedes-Benz. Now, I think in 2000, and I stumbled on this article some years back, Daimler-Benz, the makers of Mercedes-Benz cars, merged with Chrysler. Now, at that time, mergers had to be the order of the day. The competition in the automobile industry was rife, and you needed strength and capacity to cope with the market. So it was necessary for people to merge so that they do not get tossed into oblivion in the market. So Daimler-Benz was negotiating with Chrysler. Now, I can't remember the name of the chairman of Daimler-Benz. I think it's Jürgen something. I've forgotten his name. And funny enough, I thought I was going to look it up again, but it's gone off again. Now, they were negotiating with Chrysler, and they had reached a point where the negotiation was not going to go the way of Mercedes-Benz. And at some point, it was now, what do we talk about? Now, because Mercedes-Benz had done its research, had followed the process we just identified through and through, had developed its own partner, it was considering, do I disclose my partner to these guys? Perhaps if I disclose it, it will shift the tide. But when do I disclose? When do I disclose? How do I disclose is the purpose of this bullet point. Now, at that point, when they realized that they were likely to walk away from the deal, Daimler-Benz decided to do what you call a last-ditch effort. Let's just try it out. So Daimler said to Chrysler, look, we want this deal. We want this merger. But if we walk away, we don't lose. Why? Because as we speak, we are currently in talks with Ford Motors. And Ford Motors is about to engage us in a merger. So if we walk away from this deal, we are not totally lost on it. That was the moment the tables turned. Why did the table turn by that disclosure? Because Chrysler, unlike Mercedes-Benz, Chrysler did not have any other potential merger partner, and they needed to merge. But Mercedes-Benz had a merger partner, but Mercedes-Benz did not want to go with Ford. Why? Because Ford is an equally big name. So Ford was likely to swallow Mercedes-Benz. But in this merger, Mercedes will swallow Chrysler. I mean, I'm not too sure you've heard Chrysler since that time. You probably had Chrysler cars, but you probably don't see them anymore because they have been swallowed by Mercedes-Benz. As a matter of fact, that article, that research article is titled Taking a Drive, How Daimler-Benz drove away with Chrysler. So that is one of the lessons and morals you have to think about when you're asking, do I disclose, or when do I disclose, or should I disclose? So know what you want to say. It must be for a purpose. Know the purpose you want to achieve when you are making your disclosures. I talked about the zone of possible agreement earlier on. I talked about the zone of possible agreement earlier on. Now, that is the bargaining range in an area where two or more negotiating parties may find common ground. I've tried to describe it by this diagram. A ZOPA exists only where there is an overlap in each party's expectation. So let's look at the example here. You see at this end of the bar at the top is $10 million, while here is $6 million. That is the seller's settlement range. So the seller is saying that the least I will sell for is 6 million, but I am asking for 10 million. Go to the bottom bar. The buyer is saying the least what I'm going to offer to purchase this item is 4 million. However, if push comes to shove, I do not intend to go beyond 8 million. Now, on the face of it, what they're asking for is way miles apart from each other. However, in the middle here, you will see the zone of possible agreement. Why is it the zone of possible agreement? What it means is that somewhere between 6 million and 8 million, there is a 2 million. So any offer or any contract that results in the parties, any offer or any purchase that goes between 6 million and 8 million is a good deal. Any deal that covers between 6 million and 8 million is a very good deal for either party, because either party would have gone happy with the deal. So it ceases to be, oh, I was cheated, oh, I lost, I made concession here, I made concession there. I must tell you also that while the first two models talk about win-lose, this third model, model of joint problem solving resulting from principal negotiation, is regarded as win-win. And this is what you're looking at when you negotiate within the zone of possible agreement. So when I talked about you making an offer, so the offer that the buyer wants to make in this scenario should be as close to that zone of possible agreement as possible, because you know that you will not be engaging in needless conversation. Don't start from 4 million. And don't go starting from 10 million. These were the views you had before you left your respective offices to the negotiation. But by the time you sat down and you talked, the efforts to harmonize interests, the efforts to bring a collaborative result out of the process got both of you coming down to achieve a zone of possible agreement. It might be imaginary, but at least in your mind, you know that this person should accept this person should accept that. At the end of the day, the buyer knows that if he's paying 6 million for it, he's got a good deal. Likewise, the buyer knows that if he's getting the seller knows that if he's getting 6 million, he's not got a bad deal either. So because he has not gone below, he has still been able to make the needed profits that he wants to make. So that is pretty much on negotiation. Mediation, where is mediation going? We're talking basically about assisted negotiation. So everything we've talked about in mediation, we're going to find in negotiation, we're going to find in mediation. So what we're talking about in mediation really is not going to be a rehash of everything that I've talked about. It's more about the uniqueness of the process. What I'll be talking to you through the next few slides about mediation is taking you through how the process works, how that third party comes in to assist. In some jurisdictions, like in Nigeria, we do not have as yet a statute on mediation, even though we have a bill now that has done that. And of course, Nigeria has also signed on as a signatory to a convention on that was signed in Singapore on mediation. But leaving that now, the more important thing for me to share with you is that what we're talking about now is just the process. So You must have assimilated, I hope you've been able to assimilate all I've discussed so far on negotiation, because this is now talking about how it pans out in a situation where the parties themselves are not sitting down to negotiate, but somebody is assisting them to bring out what you may call these virtues, to bring to play what you may refer to as these virtues. The beauty, however, in Ghana is that Ghana has a legislative framework for mediation, and that is to be found in the Alternative Dispute Resolution Act of 2010 in Ghana. And it takes you from commencement to the end of the mediation. The beauty of the commencement provisions is that it makes clear and removes any doubt as to whether or not a mediation or how a mediation can commence. Does it have to be formal agreement? We sit down in the same room. It goes to as far as a simple telephone call, an email, any electronic communication, a WhatsApp message, a Telegram message can trigger the mediation. Beauty, one of the things that I liked about the Ghanaian statute is that Section 83 specifically states that no other proceedings can be commenced if parties are in mediation. So even if you have an arbitration agreement, and Abayomi is going to do a fantastic job on that tomorrow, or even if you are in arbitration, the more important thing is once mediation commences, every other thing stops, which shows that Ghana is a jurisdiction that tilts in favor of finding alternative means to resolve disputes. And then, of course, you have provisions as regards what can terminate mediation. How can it be terminated? Ladies and gentlemen, if you don't pay your mediator, it's one of those grounds, but let's leave that aside. Now, in the next slides following, what I will be discussing with you are the principles, like I said before. Now, I have in those slides, very much like I have done here, you will see me referring to sections of the Ghana Dispute Resolution Act. The reason I do that is not because I want us to be lawyers in this training. It is not because I want you to carry it to be looking at it as we speak. No, just follow the discussions as I'm making it and the principles. They are universal principles, but you are going to see references to statutes like are here so that in the event that you want to retire, to read more about how the Ghanaian legal system deals with these aspects of mediation, then I have given you places that you can just go and read. And by the way, it is an English and Anglophone country. So clearly we all speak English. There's nothing esoteric about the English language. You will understand it better. As a matter of fact, I make bold to say that a Ghanaian teacher taught me English language. I don't know if I've passed by your estimation, but here we go. So let's start with negotiation, mediation. What is it? It is assisted negotiation. We've talked about that. How does it arise? Again, look at the act. It says parties' agreement is one. Now, courts in Ghana can, on their own motion, refer a dispute to mediation. It's the same in Lagos. So if parties have gone to litigation and are in dispute, and a judge looks at that dispute and thinks, well, I think this can be better resolved by alternative dispute mediation, perhaps you should go and explore it. The judge is not going to need your consent to say whether you want to go or not. If the judge of his own volition thinks that mediation is a better place to go, the judge can order you to go to mediation. Even if the judge does not do that and you are parties in litigation already, nothing stops one of you from applying to court and saying, look, I've looked at this on my side. This gentleman may not agree with me, but I think that we can resolve this thing by mediation. So in the absence of that agreement, the court can actually look at what you've said and say, all right, please, parties, go to mediation. That is one thing that exists in the Ghana legal framework that is commendable. Mediation sits on certain pillars. Those are the pillars on which it can thrive. Always understand that the mediator is a facilitator. He's only helping you. It is not his dispute. He is not going to give a decision. The mediator is not a judge. The process is entirely voluntary. You probably will ask me, how can it be voluntary if the court is going to order me to go there? No, it might not be voluntary at that stage, but once you get into a mediation room, and in my practice, I have dealt with parties that have come to mediation because the court told them to come, and have folded their hands and are going to be chosen to be obstinate. For some reason, I've been lucky to be able to connect with them and get them to sign on to the process. Because, ladies and gentlemen, it is my prerogative to be unreasonable. You can tell me, call me names, call me bad, label me what is my prerogative. Oh, I'll face the consequences of being unreasonable, but it is still my prerogative. So if I choose to be unreasonable, then so be it. Mediation is an agreement to go and agree. So in fact, the Ghana Act makes it clear that a party may decide not to mediate. The law says that you wait for, I think, about 14 days. If the party does not respond or accept the invitation to mediation, then the mediation might not hold. But once that person is in the room, as a rule, I try to encourage that person to come to that. At that point, the person crosses that hurdle of involuntariness and into voluntary submission to the process, and then signs the papers. The mediator is a neutral, and your act provides for it must be impartial, it must be independent of the parties. And that impartiality and independence must run through the process. As with every form of ADR, it is party-driven. The beauty of ADR is the party-driven process that it is. Alternative dispute resolution is an opportunity for you as parties to choose who decides your dispute, how your dispute is decided, where it is decided, when it is decided. Those there are fantastic selling points for ADR. I repeat, you choose who, when, how, and where your dispute is decided. You're not constrained to a courtroom. You have the opportunity to sit confidentially, which takes me to that next point. It is the privacy and confidentiality. Privacy is you're not in courtroom. Only people that are relevant must be there. But the confidentiality side of it is that whatever you discuss there can never go anywhere else. They are without prejudice. So we'll talk about confidentiality later. So preparing for mediation, just as much as you prepare for negotiation, you also prepare for mediation. Now, if you look at the last bullet point, it says observe and apply the same preparations you have for inter-party negotiation, where you are sitting down with each other. But then you have to think about some other things. Appointment of your mediator. Sometimes parties themselves appoint, which is what I mean by ad hoc. If you have a mediation agreement that settles for institutional mediation, that means, for example, you want to go to the International Chamber of Commerce, they will be responsible for empaneling the mediator. Now, so the party can appoint, or a third party. Parties can agree that a third party can select a mediator for them. Then if there is no mediation agreement, for example, you might want to have an agreement to go to mediate. Again, if you go to your section 63, it talks about the very many ways mediation can be triggered and commenced. And you have the forms that can make up agreements there. And of course, you have to talk about your mediator's fees, because if you don't pay the mediator's fees, the mediator may be terminated. Now, mediation operates in phases. So there is the opening phase of the mediation, where the mediator is going to introduce himself, then explain the process to you. How is it about the process? We'll see very soon. Explain the process of mediation to you, because don't forget that he's not in your dispute. He's this third party that you have brought in to try to help you in resolving your disputes. So he's going to have to tell you how that process of assisting you to resolve your dispute is going to go. You must state the ground rules as a mediator. One of the things that you must learn is, let's take, for example, communication. You're speaking with me and I'm on my phone. You're speaking with me and I'm on my phone. That indicates that you're not listening to me. So the ground rules that, for example, I lay down is parties should please turn off their phones. It is distracting if your phone begins to ring while we're in mediation session. Oh, well, I have to keep my line open because I'm here on the authority of the managing director of the company. He might need to reach me, he might need to. Then put your phone on silent mode. And please, you might need to reach him. When you need to reach him, you will call him. If there is any issue, maybe we're going to have a session. If you need to go and brief him, we will allow it. But I do not want a situation where it begins to things go amok simply because your phone is disrupting the process. Please do not make inflammatory remarks. I do not agree with you means I do not agree with you. I'm not going to look at you and say, oh, what you're saying doesn't make sense. I'm not going to use words like stupid. I'm not going to use words like arrogant. I'm not going to use words like unreasonable, because I am being careful to ensure that I speak so that I am understood. Just like I want them to listen so that they can understand what I'm saying. Then information gathering phase. Now, the mediator will allow parties, first of all, to make their opening statements. And then in making their opening statements, they explain where they're coming from. And then the mediator will take it all in and try to understand. The confidentiality in mediation even extends to the notes that the mediator makes. So these are the things that they need to take. Now, information gathering is when you listen to them and you now start probing. Probing is very key in mediation. There was a mediation I conducted some years back. It had to do with a dispute over the purchase of a stockbroking license. When we got into the mediation room after the opening session and we began to probe. Now, in probing, there is something which you do called caucusing, which, of course, the Act also provides for. Caucusing means that you can meet with a party away from another person. So, while probing during the caucus session, I then found out that there were other issues like share transfers and the utilization of the company's capital and all whatnot that had not been mentioned during the opening statements of the parties. So I realized that from a buying and selling transaction dispute for a stockbroking license, the dispute had morphed into a company law dispute. Now, as the probing went further, as we gathered more and more information from the parties, we then found out that there was a relevant person that should be attending that meeting that was not there from the side of the respondents. It was during a caucus session with the claimant that I then realized that that person was the managing director of the vendor, the seller of the license, the company that owned the license. And the person who was sitting in the mediation room, as opposed to that other managing director, was the husband of that managing director, who was the chairman of the company and was speaking for the company. All right, can we get this other person in the room, because this person, she needs to be here. It was at that point during the caucusing session that I discovered that the reason she was not there and the reason that man was handling the matter for the company was because they were in a bitter divorce. So what started from a purchase dispute to a company law dispute then morphed again into a matrimonial dispute. This is what mediation does for you. So, and that is also how you begin to identify the interests that either party is trying to protect. So you then find out that in this kind of situation, you need to now leave where you started and begin to appeal and try to deal with the other issues. So before you now go back to where you started from. So those are the issues. Now, confidentiality. Now, obviously, me learning that there is a matrimonial dispute is not something that the other gentleman had told me. So when I caucus, one of the things I must do, confidentiality in mediation exists at two levels. One, for the entire process itself, and two, even within that process, if I caucus with you, what I learn during that caucus session with you, I cannot divulge it to the other party without you giving me prior consent. So as a mediator, I must ensure that happens too, because that neutrality must be maintained all through. More importantly, I must always instill confidence in both parties. And part of instilling confidence in both parties is treating them equally. If I caucus with you for 10 minutes, I must caucus with that person for 10 minutes. If I tell them I'm caucusing with you for 10 minutes and there is going to be an overrun, I need to take leave of you to go and tell them that, sorry, I'm taking longer than I anticipated, but I'm coming back to you. Please give me some time. Please have a cup of tea while you're at it, because it's taking much longer than I anticipated. That is how you're supposed to be going about it. Then you move to the bargaining phase. The bargaining phase also involves caucusing, because it is during the caucusing that you know the kind of offers that want to be made. So I talk about direct and indirect offers. So if you go back to the diagram on the zone of possible agreement, I said, look, you already know where the seller is. Don't start from 4 million. Try to move as close as you can. If not, stay within the zone of possible agreement. An offer for 4 million might be considered by the seller as insulting. But because you have a mediator, you know that it will say it is the mediator that said it. So you tell the mediator to tell that person, make an offer for 4 million. The mediator can say, all right, if the mediator feels, for example, that that offer, in light of the traction that we've been able to have through this process so far, that offer might turn the tables. And I don't think it'll be, okay, you're saying this is the best offer you can make. Well, since you say it is the best offer you can make, maybe it is better he hears it from you yourself. So you as a mediator say, all right, can you make that offer to him directly? So it is possible to make offers directly to the party if mediator says that's the best way, or indirectly through the mediator. All through that process, what you come to are heads of agreement that will come there. Then, of course, in bargaining, you have deadlocks. Deadlocks, we'll talk about that in a minute, but you have deadlocks that can be dealt with and you can remove deadlocks. And the next phase is conclusion. At that stage, you know which heads of agreement you have reached, which are the points of disagreement, confirm with the parties that what you have found as heads of agreement or points of disagreement are correct, and then proceed to make the settle, to assist the parties to make a settled agreement depending on what they invite you to do, so that you reflect those areas where there has been an agreement. Let's talk for a minute about deadlock. I'm about to finish. I know I'm probably boring you all. I'm trying to make good time. I know I have about 20 minutes, but I have just about 5 minutes left. So deadlocks arise when a party is, okay, when neither party is willing to make further compromise on any issue because of a fundamental agreement. So if you go back to the first model of negotiation that I talked about, where you make concessions. Remember, I talked to you about the possibility that in a later relationship where they're negotiating again, something is lurking in the horizon and reminding this guy that I'm not going to make this concession again. It's something similar. When you're in negotiation and a party feels maybe this person has insulted me. As a matter of fact, I remember that there once was a mediation on a libel case where the person just refused to concede. The person refused to concede to the claim, to drop the idea of claiming hundreds of millions from that person for libel. So breaking the deadlock also involves you still trying to build and probe into the interest. All that we found at the end of the mediation that was needed was a letter of apology for that person to say, I am sorry. You can imagine dropping tens of millions of naira a claim just for a one paragraph, I am sorry. That went beautifully. And they agreed on confidentiality issues. That I am sorry, by the way, was just for the mediation. They were not taking it outside. It wasn't as if the other man is going to publish it outside and say, oh, he's apologized to me, so everybody see I was right. No, that wasn't it. So causes of deadlock, unrealistic and impractical expectations. When you make an insulting offer, it sets the other person off wrongly. When you make an insultive stance, you can't get the value you want from the process. Sometimes pride and ego. There was a banking dispute I mediated where the borrower had paid off the debt middle of the month. As SMEs, I'm sure you know that dealing with banks a lot, interest normally drops at the end of every month. So this was a debt burden of about 200 billion naira. He got a good deal from another contract and paid off all his outstandings to the bank. And all the money that was left in his account, he spent it. However, he did not make allowance for the interest that will drop at the end of the month. And then the bank wrote him, because he felt he had paid the debt, how can they be asking him for interest? He ignored the letter. A month passed, 3 months, 4 months, a year went on. The interest now started growing and it was being compounded. So he was upset. So when he came to mediation, he was saying, oh, why should they be writing me and asking me for this? Why should they be asking me? Right? So when we sat down in caucus and he realized his own problem was ego and pride, because he had embarked on campaigns of calumny against the bank. He had reported the bank to the regulator, to the Central Bank of Nigeria. They had had a meeting with the Bankers Ethics Committee to review the bank's conduct and everything. All these things did not come out until we got to mediation. So it was very difficult for him to swallow his pride. And then, of course, if somebody has an emotional baggage, like I just give you an example, he insulted me. Sometimes insisting on the bottom line, like the case of the Malaysian example that I gave you. Sometimes you just don't see that other opportunity that is involved. And of course, you might have a deadlock because somebody is deploying a dilatory tactic. Let me delay and frustrate him with my delay. How do you break deadlocks? Very many. This list is not exhaustive, but there are many things you can do to break deadlocks. Change strategy, allow parties to express their emotions, listen actively, understand where they're coming from. Let them, however, realize that how more beneficial it is for them and how they can be the bigger person. How that person can be the bigger person by sometimes letting go and find an option that will be mutually beneficial to him as well, even as that person gets that concession or whatever from the party. Reality testing is also good. Reality testing, again, is about your what now. Taking that worst alternative. Is this what you want to go and face tomorrow? Do you want to stay 20 years in court simply because you don't want to agree to this? That is reality testing that mediators use as well. So the question is, what do you want from it? I said earlier, do you want a contract or do you want a relationship? I won't talk about that again. The settlement agreement is very key. The parties prepare it themselves. Don't forget, the mediator is not a lawyer, is not necessarily a lawyer, and it is not his role to prepare your agreement for you, though he can assist you. Make sure that those that are signing have the authority to sign. Also, it is known, in fact, the Ghana statute provides in section 84B, but always make provision for it. We always do here because we don't have a mediation statute. You cannot take the mediator to go and testify in court. Ensure that it states that it is reflective of the agreement of the parties. And then enforcement of mediation agreements. What your statute says, the Ghana Arbitration ADR Act provides that a mediation agreement has the same effect as an award that will be given in an arbitration. Again, Abayomi will talk to you about arbitration and awards tomorrow. But an award is normally taken to court, and with leave of the court, with the permission of the court will enforce it as if it was a judgment of the High Court. And that is what your section 57 also empowers you to do. So in summary, what do we get? What does ADR offer SMEs? Faster and less costly dispute resolution process because you save a lot of money, particularly if you meet up with a practitioner that knows what cap is best suited. There are cases that I have every day in court and I tell the parties, some go to litigation, some will stay there, some will mediation. Sometimes you might use litigation to have an edge, but you need to always consult your professional advisors, meaning lawyers, to always go there. By the way, find lawyers that are ADR advocates, because I am a lawyer. I've practiced law now for almost 3 decades. And I have seen the trajectory of law practice in whatever levels. I have appeared at whatever levels, and I'm not trying to sing my praise here, but I can tell you that there are some lawyers that all they want is just to be in the courtroom because that's where they're more comfortable. For them, mediation is too cheap. It's killing the goose that has laid the golden egg. So they will encourage you to go into that dispute arena because for every time the case is in court, they will collect fees. For as long as the case is in court, they continue to collect fees from you. So who do you want? So it's not enough to say, oh, he's my friend and he's a lawyer, therefore I will use him. Ensure that the lawyer is one that understands your business. I attended Lagos Business School in 2010 because I wanted to understand the language that my clients will be speaking so that I can connect with them at their level. So it's not all the time that I'll say, let's go to court. Sometimes I even tell the client, forgo it. What is the opportunity cost to you? So it offers you a more flexible and adaptable dispute resolution clause. I talked to you about neutral evaluation, how it's suited to a construction dispute, mediation and negotiation, how they are suitable to a dispute that started off as a stockbroking dispute, to a company law dispute, to a matrimonial dispute. For all you care, you might be able to settle everything once and for all. It is less formal, and so you do not have to go with the technical sides of procedure in a court. Yes, you have the rules that govern mediation, but those rules are done to just guarantee neutrality in the process. They are very flexible and they are in the control of the parties. It is private and it is confidential. What you reach there is not going anywhere unless and until parties themselves agree to submit it. Above all, it is consensual. That is why parties have to agree to submit it. It is consensual. It is a party-driven dispute resolution process. I hope that with these many slides, I have been able to connect with you on this aspect of mediation, negotiation and mediation. It's a bit heavy because the mediation skills course, like I said, took 6 days. So to compress it into 1 hour, 5 minutes is not an easy thing. So I can understand, and that's why I have given the statutory references, especially for the mediation process, because negotiation is more contractual. Mediation process, if you want to learn more about it, you can look at those provisions of the Ghana ADR Act, which is they're written in very simple terms. I mean, the legislators in Ghana have written it in very simple terms, and I commend it to you. With that, I say to you, ladies and gentlemen, thank you very much for listening to me, and I hope I've been able to make meaning with these many slides that I have presented. Thank you.
Thank you very much, Mr. Ojo, for that insightful and very informative session. Yes, the slides may be many, and that the information may not be too easy for them to, just assimilate everything now. That is why we'll be sharing all the slides, for the slides for all the sessions with them. So at your leisure, free time, you can go through the slides again, and if you have any questions or concern, just send us an email. We'll be able to direct your questions to facilitators or answer those questions ourselves. Mr. Joe, I don't know if you want to quickly answer a few questions that you have in the Q&A box. Mr. Ojo.
Yes.
Okay, so there are a few questions here. I don't know if you want to take 1 or 2 of them. There's one by Bashu. I think he has asked all the. Okay,
just let me know which one it is. Do you want me just go over there?
Yes, there's one on win-win mentality, and when you reach a stumbling block in the course of negotiation, how do you deal? Do you come back with another offer, or do you try to involve your attorneys? I think that one.
No. Invariably, you see, no one negotiation is the same as the other. So what the mediator does is to deploy the skills. And if you go back to the last few slides that I talked about deadlock, it's not about going back to bring another offer or whatever. If it is the offer that is seen as the issue, the mediator will identify and will guide you through the process. That is the role of the mediator. The mediator might think, okay, let's take a break for a minute. Sometimes, in fact, in some cases, everybody just sits down quietly and allow everything that has just transpired to sink in. So deadlocks are normal, and that's why the list is not exhaustive as to what you will do when you want to break a deadlock. So there's no hard and fast rule to it, but the circumstances you find yourself will typically dictate how you will resolve that particular impasse, as it were.
Okay, there's another question on section 7. I think this one relates to consent of the parties, to say that even when you're before the court can refer parties to arbitration, parties must consent.
Section 7.
Yes, must consent in writing, and saying that consent of the parties is non-negotiable. Maybe whilst explaining this, Mr. Ojo, you may also want to slightly touch on some mandatory arbitrations that may not necessarily require consent, like statutory arbitration, as you find, for example, in section 1 and one of our other sections of Petroleum Act in Nigeria that says, um, when there's a dispute in relation to license, an OPL or AML, that such dispute will be settled by arbitration. That in a way takes away the consent part of it, but maybe you just want to balance that explanation of mandatory statutory arbitration with Section 7 of the Ghana Arbitration Act, ADR Act, that requires consent of the parties before the court can refer them to arbitration.
Well, I thought I would leave the discussions on arbitration to you because that's basically your remit. But generally, right, arbitration is consensual. In fact, any ADR process is consensual. If I may backtrack, courts never lose their jurisdiction simply because you want to go to ADR. So a court is waiting to entertain your dispute. So if you submit a dispute to court, for example, the court's remit is to continue. However, parties may decide that they want to resolve their disputes in a different way and in a different forum. Consent is critical to that process. And in arbitrations are founded by agreement to go to arbitration. But Abayomi rightly points out, and I'm happy you mentioned the Petroleum Act in Nigeria and other practices, not even only the petroleum, oil and gas sector, there are even in labor-related disputes too. You have under the Labor Act in Nigeria, the Industrial Arbitration Panel. There are some disputes that statutorily must be resolved by arbitration. And in those situations, those statutes, the draftsmen of those statutes realize that there is a value, there is an advantage to that process. And so it is in that context that they make it mandatory that those must be resolved by statute. So you must go to arbitration. To that extent, the element of consent can be taken away from the parties. And it is similar to what you have in the area of mediation, where you can have a court-ordered mediation. Even here in Nigeria, sometimes courts order mediation. So the court can order it. Now, if your statute provides, if there is a law that provides that certain disputes must be resolved by arbitration, that takes away the element of consent. So whether you have a written agreement or not as to how you're going to resolve it, that statute will govern, because you cannot sign out of the provision of the statute. So once that is there, it takes that element away. But generally, as a rule, the consent of the parties is critical and is consensual. But what the Ghana Arbitration Act has tried to do is also to balance these things, because the truth be told, and I gave you the example of a mediation where a party did not want to come. The court ordered and the party did not want to come, but the mediator must show some level of skill to ensure that it gets that person's mindset changed as best as possible. But even the Ghana Act recognizes that it may not be possible to do that and allows and says, look, it may not, unfortunately, won't, but that won't happen in arbitration, because in the arbitration sphere, that third party neutral has to make a decision. So if the person decides not to participate in the process, it doesn't stop that third party neutral from going on. But to come back to the issue of consent, is a general requirement that you must have written consent. However, statute sometimes takes away that right. Oh, by the way, just as statute says that certain disputes must be resolved by arbitration, also statute says in some cases that certain disputes cannot be resolved by arbitration. So Abayomi is well aware, in Nigeria here, tax disputes, in fact, that has been the albatross of most arbitration proceedings in Nigeria. So you have to look at the statute, and I'm happy Keneth mentioned the need for you to be mindful of regulatory issues, because if you're practicing in a regulated industry, then you need to be mindful of those issues that can be taken to certain fora for resolution and those that cannot be. Just like criminal law cannot go to arbitration. I hope I've
Yeah,
tried to.
yeah, absolutely. Thank you very much for those useful responses. Um, on this note, we've come to the end of the sessions for today. We thank our excellent facilitators, Keneth, Ohene-Manu, and Mr. Sheila Ojo, for those very useful, well-packaged, very informative sessions. We'll continue the sessions tomorrow, starting with international arbitration, and we'll also get representatives of the arbitral institutions to come speak to us on how SMEs can benefit from the different ADR methods or mechanisms that they run in those institutions. Just to note that this training comes with certificates, so you will need to send how you want your names to appear on the certificates to us. Send it to info@pensburylaw.com, and we'll prepare your certificate and send your certificates to you. So thank you very much for staying with us. Sessions tomorrow start at 10 a.m. Accra time, and hopefully we'll have very robust and useful sessions tomorrow too. Thank you, Mr. Ojo, once again. Thank you, Kenneth. Thank you, everyone.
Thank you so much. Thank you.
All right, see you tomorrow.
Thank you, Abayomi.
Thank you, Kenneth.
Well done.
Thank you very much. Well done too. Very good presentation.
Thanks.